Good morning. Welcome to STS. And it's docket Thursday for Donna Adelson. Joel is locked out of his building. They changed the locks, and it's not because he didn't pay the bill, but I guess the landlord didn't like the way things were run, so he changed the locks. Joel should be jumping in any minute. So I'm going to try to carry the water until he gets here. There he is.
There he
Joel
is.
is here.
Hello, Tim Jansen. Had an early morning surprise, which was being locked out of my building where my studio is. They switched the code apparently. So here we go. Thank you for there's anyone who can handle and take the controls. It is Tim Jansen, but we are here. Surviving the Survivor, the best guest in all of true crime. And I see Teresa Luck of the Irish jumping in. And I can see already backstage Judge Everett at the bench. And we should be taking this momentarily. I told Tim the show must go on with or without Joel. That is, of course, true. This is going to be partly about this Sergeant Tim Corbett issue. Tim is COE. Can we bring up Judge Everett?
That's Chris Corbett.
What'd I say?
You said Tim Corbett.
I'm sorry.
It's all right.
You're Tim. They said Donna's going to be after all the other people they have this morning. Interesting.
That means it's going to what that means is it's going to take some time. And so they got other cases that are on the docket that are set for trial. And sometimes they have a spillover judge or a carryover judge who will try cases in different courtrooms. So they may enter pleas. A lot of guys, today is the last deadline. You can make a plea on docket sounding, or they'll tell them, listen, we don't have any other judges. Donna's case is going to trial. You guys are bumped to the next docket sounding. And they're going to be probably taking some pleas. So you probably don't want to be bored with that.
Look at this. Look at this hypothesis from Jared Ross. I think Donna's bringing hearings bring out the terrible weather in Tallahassee. Terrible here too, by the way. Last week's hearing was rainy and nasty. Today is rainy and nasty. Hurricane Francine equals Hurricane Donna. Yes. So Tim, last night, I don't know if you know this, but we had
before we proceed. Very well. Mr. Clark, is there any offer that your client wishes for you to convey to the state?
No, sir.
So that is obviously not Donna, but let's keep this up, everybody.
Yeah, this is a typical what they're doing, and they'll do the same thing with Donna. This is your last chance at a plea offer.
And I assume how many of these do they go through, Tim, typically?
It depends. It could have 4 or 5. You might have some that enter a plea. So he's apparently not too concerned with his dress for a docket sounding.
Yeah, I was just going to ask you. Donna comes in shackled in her jail jumpsuit. How come these guys are in their Sunday best here?
Well, they're out of custody, so they're not in custody. But you would assume on docket sounding that they would dress a little better. But
some people, they just have their own style.
That's true.
Shout out to Chris Robinson here. But we had an interesting show last night, Tim Jansen. We had Yindra Velasquez and Ryan Fitzpatrick, not to mention earlier in the day we had Vinny Politan. We can't forget him.
Yeah.
But Ryan Fitzpatrick was saying that he thinks that Scott Radius is going to blow this thing up. He's the one that went to authorities. He's the guy who was in Southeast Asia. He was once a club manager in here in South Florida. He's also refusing to give Harvey Charlie's money back, walking away with like $150,000. And I don't think there's much they can do there. Do you agree with him that a guy like Scott Radius can have a huge impact on this trial?
He's being subpoenaed by the defense or by the prosecution.
I think it's by the state, is my understanding.
Okay. Yeah, he can. And, I did my first article for the Democrat last night, and so I didn't address this issue, but I was going to. Most of these trials are scripted, right? both sides know on direct what each witness is going to say. They go over their testimony, and the real question is always cross-examination, because you can't script. You can try, but a witness like this guy who probably hasn't been in very much, he's new to the game. He's probably they're gonna talk to him, but he could be the Caitlin Kalen. When his name and O.J. Simpson?
Cato Kalen.
Cato Kalen, who took over the courtroom with his persona, and not because he had much to say, but because of his persona, and you either liked him or you didn't like him, but everybody remembers him.
Yeah.
So this unknown character, which we haven't seen in 4 trials, or this is going to be the 4th trial, could make or break some of the state's case or the defense case. And the defense probably, I don't know if the defense deposed him. They don't know what he's going to say, but this, I would think, goes all to the flight, consciousness of guilt in the Vietnam, right?
Yeah, that's what this all goes to. Correct.
Right.
Correct. We had Sigfredo, 2 Katie's, 1 trial. This is a 5th trial. Yeah, so it can be the 5th if you count Katie twice.
Yeah.
Mish Cavernos in Cape Town, South Africa.
That's our tour guide. She's our tour guide when we go.
By the way, look at this. Uganda is in the house. Amazing. I was in Rwanda, Gloria. I walked with the gorillas on my honeymoon. It was the best trip of my life. And Uganda is famous for their gorillas as well. Those are the 2 countries that have them.
So you can see all the other lawyers in there. That's Ryan Fields. He's another prosecutor. So they got a lot of lawyers in there sitting there. So they got several cases that they're going to go through. You don't see Dan. You don't see Alex there yet. You don't see Donna.
Yeah, not yet, but they're coming. Will we see Donna in the flesh today? Will she be there, you think?
Normally for docket sounding, they will bring him in person to discuss any final plea offers. And you saw they asked the last defendant if he had any counter plea offer he wanted to make to the state. And they said no. They want to get that out of the way. That's it. And now you're going to trial.
So Mish Cavernos, I don't know what's going on there. That's definitely not us. That's something going on with the pool camera. I hope the guy's battery is not running out. It's always something.
So Court TV is doing the pool camera for the trial. Originally, WCTV got it. And then
really?
Judge Everett was concerned that he already gave it to WCTV, but Court TV has better equipment, which gives better feed. And I guess Judge Everett ruled it's going to be Court TV. I found that out yesterday.
Wow, that's breaking news right here. I did not know that because it was supposed to be the local WCTV. What affiliate are they, Tim? CTV?
CBS. Just
CBS. Okay. So I guess that's a little better news, is that Court TV will be the pool cam, and our friend Julia Janae, the Court TV anchor correspondent, should be here. Look at this, Black Widower, generous as ever, gifting 10 Surviving the Survivor memberships. But so the question from Mish in South Africa is, are we going to see Chris Corbett take the stand today? Because Judge Everett indicated he wanted to hear from him.
I think he is going to have him, and I think that's why he's going last, so he can take testimony and get all the other people out of the courtroom. And I think Chris will testify, and I imagine Chris will be well prepared, and he's going to clearly say what he did besides just look at things. He's going to he did an analysis.
Francine in Arkansas, I just saw someone say that they are looks like the shot just went down. I'm just watching backstage, so I know Space Coast is working on it. Space Coast can't do it, nobody can. So look at this. STS keeps knocking it out of the park. Yeah, we had some good shows yesterday. Tim Jansen. We also had Yindra Velasquez, who's a former high school friend of Katie Magbanowa. By the way, she taught me how to pronounce it, and I still can't, because the way she pronounced it was way harder for me. So I'm just going with Magbanowa. But Ryan Fitzpatrick, who's subpoenaed and is set to testify in this trial. Tim Jansen last night, he broke down. He started crying at the very end. He said he feels horrible for the Markels, and he said that he just wants this to be over for everybody, because he was talking about the difficulty of testifying and getting all this hate mail. It's interesting because we talk about the Markels, rightly so, all the time, and there's just this crazy ripple effect. And last night I didn't expect it, but even the witnesses kind of suffer through this because they have to relive it. Do you find that in the murder trials that you've adjudicated, I guess, that you've worked on? The witnesses get stressed? I mean, this is a kind of a different circumstance because they're coming back basically every couple of years or every other year for yet another trial. But he seemed very emotional, like it was really getting to him.
Yeah, witnesses go through, they live these cases too. It disrupts their lives, and especially who they're being called by. My last murder trial, it was a small community. We had witnesses, and they were scared to death to come testify because their testimony was going to be favorable to us and was going to shed some light on the victim. And they lived in that community, and the family was very powerful in the community. So they were more pleased that we reached a resolution than we were, because they have to live in that community. And in small communities, you get that scarlet letter on your head, even though they're being subpoenaed, and it affects their families forever.
Yeah. Tim, I know you have a little info on this one. Look at this. Ashley Rose. She would never change her plea. Silly question. Some people are asking about that. Have we given any thought to Donna's sense of style? I can't see her wearing frumpy clothes. Would Harvey bring her outfits, do you think? What do you know?
Well, that's interesting. We had this conversation, Joel, and a good source, close source, said he's never seen anything like it, that they brought so many clothes last Friday at the courthouse, and 2 female bailiffs sat there while she did a dress rehearsal for what she's wearing for the trial. This person told me they never have seen that ever before happen. They also said that she was complaining about her hair, wanting to get her hair done. And he said if she gets her hair done, that brings someone that will be absolutely appalling. So we'll see what she does with her hair. She's going to clearly have clothing. He said she had tons of clothing outfits she was trying on. And it was funny because, I think it was 30 minutes later or so, I opened in the elevator, and there's Dan Roshbaum and Alex Morris. And I believe it was the female lawyer that was originally in court for her. And Dan had this Cheshire looking grin. Alex was wonderful as always, nice guy. Said, "Hey, Tim," he goes, "You know the gig." And I'm like, "Yeah, I know the gig." So it was kind of surreal hearing that about the dress rehearsal, and then seeing the lawyers in the court in the elevator, which was much later in the afternoon after that hearing in the morning. So they were there all day.
Yeah. I mean, by the way, Space Coast and COE, I know you're just fixing the shot. Once you have it, can you just put it up, even if it's other people? I just want people to know. There we go. Thank you. So we are, for those joining.
So look at this. This is a good example. This is a typical defendant who is in custody at his docket sounding. Look what he's wearing. His lawyer's standing there. No fluff, nothing. That's how you normally appear when you're in docket sounding if you're in custody.
He's a big dude. He is cuffed. He looks like he has the waist chain going on there, and he's in his jail attire. Could this be? This looks like, obviously he's in custody, Tim. This could be anything, right? This could be.
It could be any charge. We don't know. It's just guessing. I wouldn't know, but
yeah.
He's clearly in custody.
Yeah.
I could almost tell by the prosecutor, it looks like it's a domestic or sexual battery, because that's the cases that this prosecutor handles in that division. So you can glean a little clues by who the prosecutor is.
Yeah. I don't want to say he looks like he could be that kind of guy, but I don't know. But Tim Jansen, so back to the clothing. This is what everyone wants to know. Donna Adelson's wardrobe. And we hope she's not. And that
gentleman standing there is one of the oldest lawyers. That was Baya Harris, and he is 84 years old.
84 years old, still keeping himself busy working. What's his
Still
name
keeping
again?
this. Baya Harrison. He does death penalty cases.
This is the pool camera, in case you're curious. I don't know what the hell they're doing. Now we're back. So we're going to keep. That's a different Law and Crime. That was a different courtroom, I believe. Law and Crime is trying to figure out. I'll pop this off until these pool cameras or something else. Tim, I know I've asked a question before from Rosemary Romero, but can Tim answer why Wendy would not get immunity if she testified for the defense, and why she could plead the fifth if called to the stand?
That's a great question, Rosemary. And I lived this situation with Brian Winchester. The defense does not have the authority to grant immunity. The only immunity is when the state compels you through a subpoena to testify. So when I went to court and when they granted immunity for Brian to testify against Denise, I went to the court and told the judge, he is going to plead the fifth to any and all questions that the defense may have, because the defense does not have the ability to grant immunity. So the court and the prosecution agreed that the immunity would cover not only his direct testimony, but cross-examination and by test and redirect. You got to make sure you do that. Okay. I did it, and Hankinson was not happy I did it, but I was protecting the record to make sure, because if you're there answering questions from the defense, that may or may not be immunized.
Hey, Tim, by the way, look at this. This is a first from Matthew Burney. Hello from China. Did not know you could watch STS in China. If I could get all 1.8 billion Chinese to watch this would be bigger than Mr. Beast. I'm coming for you, Mr. Beast. We're all coming for you, Mr. Beast. Don't get too comfortable. Guy has 313 million subscribers. It's unreal.
Could you imagine? That'd be great.
Yeah, 11 months. That guy, 313 million subscribers is like, I don't even know, more. It's like probably 10,000 times what CNN, more than that, gets in an evening. So that's pretty funny that some 26-year-old kid literally has that kind of viewership. But anyway, I digress. So you think we're going to see Corbett testifying here, which is interesting. We talked about Scott Radius. People keep saying that apparently he was fired from his job as a police officer in Plantation. I'm not really sure the circumstances.
Who was fired?
Scott Radius was once a Plantation police officer. Allegedly, he was dismissed from his duties there. And look at this. Sweden and the Netherlands are here in the house. Katie Kool-Lady had a question that I just skipped over. Obviously a friend of the show. She's going to be in Tallahassee. She was asking, are there going to be any more, something along the lines of any more final plea? I told she texted me that question, and I guess thought Ruth was wanting to know. One, no plea offer will be without the family, Ruth, being involved. Today is the last day. Question, by the way. I'm sorry.
Today is the last day of the plea, any plea issues. Today is the last day where you clean everything up. You clean everything up. It's like right before you do an open house, right? Everything's got to be done today. The judge may address the conflict again because he wants to make sure that's on the record so Dan doesn't try to testify later on. But he's done it twice, maybe 3 times in these pretrial hearings. But they'll ask if there was any final plea or ready to go to trial. And I think he is going to want to make a factual finding on the record with Chris Corbett. So I think he will hear testimony from Chris.
Look at this question. Hey, Joel, what are your thoughts on the UFC Sphere event? I'm a little underwhelmed by the card, but the Sphere looks incredible. I actually know I have a bunch of friends that went to Dead shows, the Grateful Dead there. They said it was incredible. So I think it's going to be an amazing event. They're making it like a movie about Mexican fighters. So in between each fight, there's going to be a short documentary that they play on the Sphere. It's going to be pretty cool. Tim, but the card is okay. From Bizette, what are the motions? I mean, besides this Chris Corbett issue and besides talking out, what the plea issues are, what else? I mean, we had this sealed motion people think is related to Rob Adelson. So what else could we potentially see? We're trying to get that feed back up right now. As by the way, for those joining, this is not officially started yet. They're going through the rest of the docket. So that's the deal with that. I see Space Coast working on it. But Tim, what else could we see today?
I think the motion in limine will certainly be brought up, and that was under seal about Rob Adelson. I think that will be brought up. It'd be interesting if it's going to be done in open court. They're going to do it at sidebar, but usually everything that's done in open court, it's a public trial. It's a public venue, and unless something is so, the judge says let's do it at sidebar, it's got to be done in courtroom. And so we'll see. We may hear what they are trying to keep out. That'll be interesting.
Just curious. This is a question I'm just going to bring up. I didn't really read it from Craig Brown. Just curious, Tim, if Georgia Kappelman can ask Donna if she wants to admit to having participated in the murder of Dan. If she says yes or no, both incriminate her. That's kind of interesting. Would you ever ask that outright? Because
well, you know, it's the question, right? Are you still beating your wife? Really? There's no good answer when it comes out, and it looks bad. She might do that at the end, depending on how Donna testifies, but she may say, you were the impetus for this. You were the reason for this. And I truly believe the state believes that she was the impetus for this crime. Now, in the article I wrote for the Democrat, this case is a little different than all the other cases, right? Those other cases all had direct evidence and witnesses testifying against the individuals. This is the first case is strictly circumstantial evidence. The only person that can directly implicate Donna in this murder would be Charlie. So everything else is circumstantial evidence, and circumstantial evidence can be just as strong, if not stronger, than direct evidence cases, especially with eyewitness testimony. So this is going to be a challenge for the state because they have to put all these pieces together, put them together. They have to convince the jury that circumstantial evidence is enough, and there's a jury instruction on that. So you're going to see a little different trial than you did with Charlie and Catherine and the other two.
Tell you what, I'm not going to survive long if the pool camera is this finicky ahead for the trial because I'm watching behind the scenes. They're having trouble with this pool camera, and Tim just let us know that Court TV took over the pool. I don't know if they've done that yet, but it was the local CBS affiliate in Tallahassee, WCTV. So it went out for time. It looks like the other channels have lost it, and Space Coast is working on it. Zach Sawyer, just back to this, Tim. So this is a sealed motion. Just kind of digging into it a little more. What would the state basically get from Rob Adelson? Like, would he have to come with some sort of quote unquote receipts? Because he can get up on the stand and say things, but can't the defense just say that that's all hearsay?
Well, I don't think he's going to be able to introduce just hearsay unless it fits a hearsay exception, right? Statement against interest. Someone says something, a confession, that's a statement against interest. It's hearsay. All of the hearsay really goes to the indicia of reliability. Is it reliable? And a lot of the exceptions kind of throw in a reliability factor. Like there's a dying declaration. That's admissible in court if someone's shot and they're dying and they say something, because there's a person's not going to lie when they're dying, right? A statement against interest. A person wouldn't say something against their own interest if it wasn't really true. So all hearsay is to keep out prejudicial stuff. Hearsay exceptions allow things in that have some indicia of reliability, okay? And that's kind of like the little minor thing you should consider on that. And that's what the judges consider.
From JJEHP, does Tim agree that the case is stronger against Donna with the jailhouse calls, which apparently are not being brought in except for the hot mic one, one-way flight to Vietnam, and the Donna phone tablet seized recently, all which happened after Charlie's conviction?
Well, you say stronger. I'd like it if we had an eyewitness that saw Donna dropping off the money. I'd like it if, I'm not saying I like it. It's not me, it's the case, but I'm saying I would agree it's stronger if Chris Corbett can testify that when Donna said just outside, and he can, with the phone data, prove that she was outside, which would buttress the testimony of Catherine that his mother just dropped off wet money. That would make the case stronger. But we don't have an eyewitness that's going to put Donna. Donna was clever. Donna kept out. And so it's going to be more challenging in some ways for them to prosecute Donna, but in other ways, the flight to avoid prosecution is so damaging. Her conduct is so damaging. And I wrote in my article that, is Donna going to testify? I think that Charlie is going to be called to the witness stand, and Charlie's going to try to give the defense for Donna without having Donna to testify. And they're going to wait and see how Donna does, and how Charlie does. And if Charlie does well, they may not need Donna to testify, because there's so many dangers of a defendant testifying.
Oh, that's interesting. Right now, just a heads up, it looks like the pool camera went out and there's only a Zoom. So the COE is working behind the scenes. I am going to give me 1 second.
You wonder how a pool camera can go out.
It's kind of crazy that it can happen. I just sent Ruth Markel a quick message because I know she's watching on the Zoom.
I handled it already. We're working on it. You can continue taking questions.
Welcome to my world.
We've got our marching orders.
Yeah, I love it. It's hilarious. Mary Binney, Tim, Charlie's first lawyer motion will be dealt with today as defense wants to use him. That's David Marcus. I didn't really fully understand all of that. What can you tell us?
I saw his response. He filed a motion to quash the subpoena, that anything he had was privileged, anything else is not relevant. He doesn't want to travel all the way up there. And I think the judge could handle that. I think he will. It's really hard to subpoena a lawyer that represented somebody and get them to release attorney-client information and to show it's relevant. However, if it is attorney-client privileged, the client has the privilege and the client can waive it. So if David is saying it's privileged, not necessarily true. It's the client's privilege, not the lawyer's.
Interesting distinction. Tim, we talked about Corbett from Mish again in Cape Town. Will the judge actually, does he have to make a decision today? We're running out of time, or can he wait till the trial begins?
He's going to make a preliminary decision today so the parties know how to do their openings. He may reserve part on everything. I saw a note that Mish had broken ribs and she wanted to ask how to deal with it. And I hope that she doesn't have broken ribs, because I don't wish that on anyone. My recommendation on broken ribs, you got to keep moving. You got to get up even when it hurts. Because if you don't, you can get pneumonia in the lungs, and you got to keep moving. That's what they fear the most, is if you get pneumonia from not moving. And with broken ribs, you don't want to move. So I learned the hard way. I was in a funny story since we got time. I was in the hospital and the doctor came in and said, "Oh, you're over 60, multiple ribs. You got a high mortality rate." 30 minutes earlier, I told the nurse I wasn't getting out of bed. After that guy came in, I was out of bed. I was walking the halls, and they said, "Well, we can't get you a wheelchair because you're running around the halls. You got to move, and try not to cough, and don't sneeze. That really hurts."
Yeah. Hey, Mish, let us know what happened. I hope you're okay. Sorry to hear that.
Did I
DB,
answer?
thank you.
I think I answered her question. I think I did.
I think you did.
Okay.
When you're the pool camera, you should probably be able to get a shot up from the courtroom. Otherwise, you probably shouldn't be pool camera. But got this up now. We are waiting. This hearing has not started. The pool camera, for those of you who are just joining, is having issues, not us. And so we are waiting to see if we can access the pool camera. Donna's further down the docket this morning as they are dealing with other defendants before her. Did Tim just say Donna was wanting to get her hair done? What's the deal with that? Does she have that right? Tim Jansen? I mean, can they get her hair done? Doesn't she have that right or no?
Well, I had that issue with my defendant, and he was able to get a haircut. I don't know if they're allowed to bring someone in to bleach her hair or I mean, she can get a haircut, but I've never had a client get their hair bleached or darkened, I guess you would say in her case. And if that happens, that would be the first. So it'll be interesting to see. I thought it was great that you got to see the courtroom with other defendants, how they are treated, how normal process is, and then compare it to what happens to Donna, because you're going to see a little different. She's given a lot more latitude than most of those other defendants.
Katie Kool-Aid, you can be a STS special correspondent, the red carpet from Leon County Courthouse, addressing Donna's wardrobe. We'll have to see what she is wearing in court.
Is Katie in court today?
I don't think so. I think she's getting
okay.
there next week. Joel,
Okay.
this is true. I'm stressed out because I don't know what the hell's going on with this camera, and it's bothering me. But if, like I said before, Space Coast can't figure it out, no one will. Definitely, I never want to wear scrubs. By the way, people are asking, how is Ryan doing? I talked to him right after the show yesterday, and he actually thanked us. He said he felt he felt much better. Again, if you guys didn't see the show, it's worth watching last night because it was a different perspective from former and current witnesses, because Ryan is testifying this time around. But he got a little emotional at the very end, and he's doing well. But obviously, it's the stress of these big, high-profile trials, and he was talking about all the kind of the hatred that he gets, and he's really just kind of, pardon the expression, caught in the crossfire here because he's friends with a guy. He didn't know this guy was Charlie Adelson, and he didn't know that Charlie was gonna do this. And you can't control what another person does. But Lori Keith here to Tim, I have a question regarding Donna's phone at the time of her arrest. If Donna hadn't had her phone in her possession, would they have been able to take her phone, or was it listed in warrant?
That's a great question. And, police officers are very clever. If they see a defendant that they know has a warrant for their arrest and he's walking towards his car, they normally always wait till he gets in the car so they can make the arrest, and then they can impound the car and do an inventory search without a search warrant, right? In this case, she had the phone on her, so they can take possessions on her. They probably didn't go through it until they had a search warrant for the phone, but they actually collected it. If the phone was not on her, then they couldn't have taken her phone. Say it was in the briefcase and Harvey was carrying it. Unless they had a search warrant for the phone, they couldn't have gotten the phone. They'd have to get a separate search warrant like they did for the house and the computers.
It's part of the Constitution. You got to get those search warrants. By the way, tonight, 7 p.m. Eastern time, the handsome Tim Jansen is back, and we have 2 judges tonight. And so we're once again going to we're going to hash out everything ahead of the trial, but also get the perspective from the judges. So the thumbnails being Judge Stephen Everett, all the things he is going through and dealing with ahead of this trial. So another perspective should be interesting, and Tim Jansen always brings the heat. Still not seeing the hearing. The COE promises me she's working on it. Ida Shaw, JD, from one lawyer to another. Tim, what has been your favorite / best experience as defense counsel? What fuels you? Good question.
That's interesting. There's 2 cases, and it's funny. It involves 2 athletes. One was going to the Heisman Trophy with Jameis, getting to hold the Heisman Trophy. Secondly, I had a Florida State Mr. Football player. He was charged for armed robbery. He had a scholarship at Marshall. He was going to be a quarterback. The school took the scholarship away from him because they said they couldn't have a felon be their quarterback. I was able to get all the charges dismissed. I convinced the coach to give him his scholarship back. The mother thought that he had lost a scholarship. We had a press conference in which we announced that all the charges were dropped, and I was given permission by the coach to give him a Marshall hat and tell him his scholarship was back. Um, the family had tears. I think the reporter had tears. I think I had tears in my eyes, because whenever you can do something and right a wrong and use your legal skills to do it, it was impressive to me, and it was important to me because I was doing good, right? Using my talents to help someone's life.
And that is important. Everyone needs a criminal defense attorney if they get in trouble. From your latex spouse, interesting title for a name. Joel, what time would you recommend I get to the courtroom to get in line to attend the trial on Monday? I know the courthouse opens at 7:30 and the trial starts at 9, but what time should I get there? Honestly, for jury selection, I don't think it's going to be too hard to get in. Most people are not that interested in that. And by the way, the trial begins on Tuesday, not Monday. Jury selection is Tuesday, just so you know. I'm driving up on Monday with Steve Cohen. However, I'm not sure. For the Charlie Adelson trial, there were always seats available. There are no media credentials for this, so Court TV, STS, anyone else who's quote-unquote media does not have any kind of preferential treatment, except for maybe the pool photographer from the Democrat and the pool camera. Everyone else, it's first come, first serve. I don't know. It's a big courtroom. It was never a problem at Charlie's trial. I think the day of the verdict or the day Charlie took the stand, it was obviously very crowded, but you could still get a seat or two. Not sure how it's going to play out for Donna. We will see. Thank you to Lindsay Shea. Joel, you are way better than Mr. Beast. Although he's way bigger. That's okay, though. Yeah, wow, look at this. Mish Cavernos, fractured ribs. That's not good. I'm finally seeing her comment here. And look at this, watching from Japan. Tim, I've asked you this before, but I'm just curious. What is it? Why do we have people? I'm going to read off a list of all these exotic countries. Why are people in Japan, even China, communist China right now? We've got people watching. Why do you think that is? And of course, Windsor, Ontario, Canada, it says here.
Well, with the internet, with YouTubes, with all these other social media outlets and podcasts, people develop an interest. It's got a very interesting case. It's reaching now to the grandmother, mother-in-law, and there's a lot of interesting factors involved in this case that drive people. And murder is probably the most interesting case to people, other than, people aren't that drawn to an armed robbery or a sexual battery or a burglary, but murder cases draw people's attention because a life is lost, penalties are very high, and a lot of resources are put into these cases. So you're going to see a lot of interesting evidence that you would not normally see in a normal case.
This is funny from Mark M. It's actually an interesting idea. Cover Mr. Beast's court case. Then, yeah, there's some stuff going on with him. Apparently, some safety on his sets, or lack of safety on his sets. Tim Jansen, we talked about this too, and you kind of already discussed it a little bit. Is there any chance for sort of a last minute surprise that Donna cuts a deal, or that we find out that Charlie cut a deal and is flipping on Wendy? If this is completely conjecture and a hypothetical, if Charlie was to flip on Wendy, when would we know that?
It would have already happened. They would have alerted the judge. Judge, we have a plea. He would have taken that plea first so the pool camera could leave. He's keeping the camera there now because he has not been alerted of any plea, and he knows he's got a hearing, so he's going to get rid of all the other cases. So we would have known that. In my murder case, we let the judge know immediately, and we took it as quickly as possible. We would have heard something. There would have been some scuttlebutt. We would know something if there was some kind of plea. I don't believe there's a plea, and there's no plea she can get. What are we going to do? Give you 25 years instead of life?
So what I mean, is there anything at this point, like 4 days out, that could derail the start of this trial?
Maybe one of the lawyers getting ill.
That's it. Well, Rashbaum, I think he broke a ankle, I think, last time.
That
This
doesn't
time,
count.
yeah, I hope
Broken ankle doesn't count.
he has currently a torn ACL, so I hope that's healing up.
So I did tell you, my sources told me that Alex Morris will be picking the jury, and Alex Morris will be doing the opening.
Breaking news on STS, ding, ding, ding. You just heard it here. Say that once again, Tim Jansen, for those who
Alex Morris is going to be picking the jury on Tuesday, and he will do the opening, and he's going to do a couple witnesses in the trial.
How long do you expect jury selection here? I felt like it was so quick for Charlie. Within like 2.5 days, it felt like that they had seated a jury, 3 at the most. But what about with Donna? Apparently, it gets harder each time with the publicity of the previous trial. So, what are you expecting if it starts on Tuesday? When are we going to have a jury, Tim?
Yeah, you're right. I think with Sigfredo and Rivera and Magbanua, the media was there, but it wasn't really there. And then, but by the time it got to Charlie, then the media really increased. So you probably have a lot more people in Tallahassee know about the case and heard about the trial now because of Charlie's trial. So it's probably going to take a little more to get a jury selected. So it could be Thursday. I mean, we might get openings on Thursday, maybe on Thursday afternoon, but hopefully it'll be Tuesday, Wednesday. They'll have a jury by Thursday morning.
Wow. So that's pretty quick. So this thing could get underway.
A lot of people live their normal lives, Joel. They're working and they're sending their kids to school.
Yeah.
They don't know anything about this case, right?
Yeah. It's interesting because we're so focused on it. But when you're in Tallahassee, it's not like people are going on, like Tim said, with their lives. Jeff, everyone is having feed issues. Might be an in-house tech issue. I put in calls to the courthouse, but they are all hands on deck right now. Everyone is scrambling. There is a problem with as you just heard, the pool camera. COE, if anyone gets on it to fix it, it's going to be the COE who is where I could see them working on it behind the scenes. If for some reason the pool camera is not up and running for the hearing, I'm sure we'll be able to get it on some sort of delay, possibly via Zoom. And COE, let me know if you want me to have you reach out directly to Ruth. I know she's watching on Zoom, so let me know. Hit me up, either jump into this or yes.
Just want to update you. So I did put in a call and an email and a text to the court, but since they're dealing with stuff on hand, they will probably be delayed. The way Zoom works is you have to be admitted into the room. So while family is watching remotely from Zoom, we cannot be admitted. All right, let's see if we can get this back up. Hold on, let me.
All right, do your thing, COE. Do your thing. Okay. There you go. Best team in best guests, best team in all of true crime. Like I said, if the COE can't do it along with Space Coast, I don't think it's going to happen. But I mean, I think we will get the feed. Again, for those who are joining late, Donna is lower down on the docket. So she has not appeared in court yet, as far as we know. There's a Zoom for the families, which we do not have access to. And otherwise, we need to rely on the pool camera, and the pool camera is not up. So no one is able to see this right now. And we are waiting to see if we can get the pool camera up and ready before Donna gets into the courtroom. And if not, we'll probably get it to you on a delay here. Interesting question from G. Lander for Tim Jansen. Can the prosecution, Tim, hire an expert if there's a portion of analysis that Chris Corbett is disallowed to make? In other words, if the judge says he can talk about this. Oh, I'm seeing something now.
Very well. You may be seated.
All right, here we go.
Here we go, everyone.
The issue the defense needs to raise moving into next week. Then let's go ahead and address Mr. Marcus's motion to quash the defense subpoena Mr. Marcus, good morning, sir.
Good morning, Your Honor. Nice to see you.
You as well. I have reviewed your pleading. What is the defense's position concerning the trial testimony subpoena?
Judge, the defense doesn't seek to elicit any testimony related to Mr. Marcus's attorney-client protected conversations with his client. There are three categories that the defense seeks Mr. Marcus's testimony. The first is the state's indicated and they reaffirmed to Your Honor that they intend to ask Investigator Isom whether or not Mr. Marcus called immediately after Katie McManua was arrested. The jury, if left there, the jury takes away that someone or somehow the defendants are all in cahoots, if you will. The defense believes that Mr. Marcus would testify that that is not the case at all, and he would provide information as to how it was that he received information about Ms. McManua's arrest and how he knew to call Investigator Isom. That's the first category. The second one is the state has investigated vigorously to try to pinpoint that the Adelson family has provided legal fees for other lawyers or other co-defendants in the case. I don't know whether the state seeks to elicit testimony of that nature, but as recent as January of this year, the FBI was down in Miami speaking with Mr. Marcus about such things. Mr. Marcus provides an explanation that doesn't involve attorney-client privilege that didn't happen. Mr. Marcus made a suggestion of the potential legal strategies involved, but nothing ever came to fruition, and there were no discussions with any co-defendants or the Adelsons. And then the third category, Judge, is there's a text message between Mr. Marcus and his client, Charlie Adelson, at the time about him having seen or bumped into Katie McManua outside of his office. And there's a comment about something to the extent of it being a coincidence, but there was no conversation that was had. Again, if the state elicits that testimony in all three of those categories and it's left hanging, it goes unanswered. But in each circumstance, Mr. Marcus is able to respond, and I don't believe that it invades the attorney-client privilege.
Mr. Marcus, I'll allow you to respond to what the defense is proffering and why they would seek your testimony.
Thank you, Your Honor. So I'll take the easiest one first, which is the last one. I had not heard about this text message between me and my former client, but that would obviously be privileged. And so any testimony regarding a text message between me and Charlie Adelson, I would not be able to comment on. So that I think is the easiest one. Let me take the other two.
Let me ask you one question.
Is
before
Charlie
you
waiving the
continue.
privilege?
Mr. Adelson has not waived any privilege with regard to you.
Correct.
You may continue.
And yes, I have not been informed that he's waived any privilege by him or anyone else.
Yeah.
The other two categories, and I'm sorry for not looking always at the camera, looking at my notes here, Your Honor, but the first is the call to Detective Isom. So I guess I just don't understand how the state putting in this evidence is relevant, and therefore the underlying evidence in my response to it, I think, should be suppressed. The idea that on the morning that Katie McManua was arrested, I learned of that arrest and called the detective to find out if Charlie Adelson was being arrested. There's nothing wrong with that. That's what any good lawyer would do. The defense is right that I would respond to any nefarious suggestion by the state that there's nothing wrong with me calling the detective to find out if Charlie was being arrested that morning. But I guess my response would be, I don't think that initial evidence should be able to come in that I made a phone call to the detective to inquire about Charlie. Certainly that has nothing to do with Donna Adelson. And even if this was a trial about Charlie Adelson, I don't think it would be relevant, Your Honor. I was trying to find out whether the detective that morning was going to arrest Charlie. And nothing's wrong, nothing untoward or abnormal about me calling the detective to inquire about that. So I would ask that whole little snippet be excluded, the underlying evidence, and what my response would be to it. The final thing about legal fees, I addressed this in my motion. I've spoken to the state about it, so I don't think they're going to elicit anything about this. They've released me from my subpoena on this issue, so I'm not sure that the defense needs me to rebut anything, because my understanding from speaking to the state is they don't intend to elicit anything on that issue.
Ms. Kappelman, Ms. Dugan, are you seeking to elicit any information or evidence during the trial that would concern Mr. Marcus?
Potentially, yes, Your Honor. We are seeking to introduce the evidence that I mentioned previously at our last hearing about the call to ISIM.
And the relevance hook of this would be, it goes to your conspiracy theory, or what exactly?
Yes, sir, exactly. Would I get into anything about the offer from Mr. Marcus to Catherine McBano's attorneys to pay her attorney's fees on behalf of the Adelsons? Potentially, yes. And what's the third question?
I believe the last matter
well,
was any text message between Mr. Marcus and Charles Adelson when he was representing him.
Yeah, I think that the defense has mischaracterized that evidence, but that is a piece that could potentially be inquired about as well.
All right. As to the first issue of the phone call and whether it goes in any form or fashion to the conspiracy, what I'm going to rule is the following.
It's admissible.
State may inquire as to the topic. If the defense has a factual related line of questioning to ask Mr. Marcus, the factual line of questioning will be permitted. Nothing that goes into attorney-client privilege may be inquired to. Is everyone clear on this?
Yes.
You know, Dan can get Charlie to waive
As to
that
the
privilege.
second line of questioning. Again, Ms. Kappelman, this is being offered for what exactly concerning any possible agreement or payment?
Yes, same relevance argument, Your Honor, that it goes to conspiracy, the existence of the conspiracy.
Right, as to this, were the defendants, well, I believe the privilege argument gets a little more thorny at this point. What exactly can Mr. Marcus offer that would not be privileged on this issue?
Are you inquiring to me, Judge?
Either party.
My understanding, and Mr. Marcus can correct me where I'm wrong, is that there was a conversation with Katie McManus' counsel. I don't believe that Mr. Marcus conferred with his client, but it's something that he does in his normal practices, which a lot of lawyers do, myself included, call co-defendants counsel if there's a necessity of sharing expenses. I think it was his suggestion, and just that, his suggestion versus the Adelsons.
That is a normal
Marcus, is
procedure.
there any argument as to why this is privileged specifically?
No, Your Honor, if I'm asked the privilege question on the stand, of course, I'll just invoke it at that point. I have no problem doing that, Your Honor. Your Honor, if I could just be heard for 1 second.
Go ahead.
There is
He really doesn't want to come testify.
Tim is going to explain all this in a minute.
Conspiracy and crazy conspiracy theories. There is no basis to argue the existence of a conspiracy by my calling the detective to find out whether Charlie Adelson was being arrested that morning. There's just no, they have to at least allege some tie, some basis in fact to argue that there was a conspiracy that would have some relevance in this trial. I was calling to find out from the detective whether he was arresting my client that morning. There's nothing tied to any conspiracy, certainly with Donna Adelson. So it's just a conspiracy.
The defense can make that argument, but the judge is not going to keep it out.
I fully understand where you're coming from with both your pleading and your position this morning. As a factual issue, did the phone call take place? There is nothing protected concerning that. How that fits into the larger narrative of what may be admissible or not, yet to be determined. The state, they have their fair opportunity to put on their case.
Yep.
If further objection needs to be raised at that time, I will address at the time. But as to the pure factual issue and whether or not you have knowledge on that topic, that does not go to privilege. That is where they will be permitted to inquire. That is where the defense will be permitted to rebut.
Right.
Nothing more, nothing further.
Yeah. Everett's
As
just
to
good.
the second issue of the offering of fees, is there any privilege that you can assert concerning this?
No.
Or this was just an idea between you?
Legal fees
Yeah,
don't
that's
fit
right.
any privilege.
The latter.
As to that topic, factually, it may be inquired into.
Right.
How this again fits into the larger weaving of the evidence. If there needs to be an objection at that time, it may be raised, but on the pure factual issue, state may inquire, defense may rebut. As
That's
to the
right.
third issue of the text message between attorney and Mr. Marcus and Mr. Adelson.
I have my facts wrong on that, Judge. I'm sorry for interrupting. The message is actually,
Wh-
Mr. Marcus.
Katie, you're not alone. I'm not
Great.
understanding
Great.
99% of this. That's why we have Tim.
indicated with
We're going to
the
go
mother
over all this after the
with
hearing,
Mr.
piece by
Marcus.
piece.
Mr. Marcus had indicated that he had bumped in to Ms. McManus. So my sequence of events a little off.
And the state would be seeking to offer this also under the same conspiracy theory,
Yes, Your Honor.
right? Mr. Marcus, are you alleging or asserting at this point that a privileged matter was discussed through that text message?
I don't know what text message they're referring to, Your Honor. I've not seen it, but if they're referring at all to a text message between me and my client, of course, that would be privileged.
That's true.
If I'm hearing Mr. Morris right, he's now referring to a text message between Charlie Adelson and Donna Adelson. I don't know whether that would be privileged or not. I doubt it, but I don't have any, that's not between me and my client and my former client.
Was this a communication that was captured through the wiretap?
No, sir. It's part of what was captured off of the devices that were searched.
So this was a text message from Mr. Adelson to Mrs. Adelson?
That's correct, Your Honor.
All right. As to that, Mr. Marcus, if it does not include any advice or opinions that you're providing to your client, if there was no joint defense agreement concerning them, ultimately this can be argued as a communication between co-conspirators. It just merely mentions your name, if I'm understanding this correctly. Is there any correction that needs to be given on this point?
No, Your Honor.
He's,
Well,
he-
as
he's
to
right
that,
on the money.
They may
Judges,
inquire as to the communication, as to anything that Mr. Marcus discussed with Mr. Adelson that may not be inquired into, but the substance of the text message, if the state in some way is going to argue this goes to conspiracy, they'll be given an opportunity to do so. If an objection needs to be raised, you may do so contemporaneously during the trial itself. So Mr. Marcus has a better opportunity to plan. The parties know when he would actually need to testify. I'm sure he has a very busy schedule. And
Wow.
we're not trying to create a hardship or inconvenience as it relates to his work and business.
As soon as the state rests, the defense intends on calling him.
Ron, I believe your previous estimate, Ms. Kappelman, was 6 or 7 days.
Yes, sir.
Let's pinpoint on the calendar then, at least a projection that will assist the witness in determining when he would need to be present.
see, he's a great judge. He's trying to make it
17,
less inconvenience for the
having jury
witness.
by
Some judges
Thursday,
say, you be
19th,
here,
first
you're
day of
subpoenaed.
trial would be Friday the 20th. And that means by Friday the 27th, potentially the state is resting its case, which would lead us then to Monday the 30th, the beginning of the defense case, unless I'm off in my calculations.
You're correct, Your Honor.
You're correct. And the defense has a bit of a time pressure also because of the Jewish holidays.
Mr. Marcus, if you can go ahead then and mark on your calendar as to when you may potentially be called, starting with September 30th. If there is any hardship that you need to address in other cases or matters that you're involved with, please let the parties know. If it's another state court matter, perhaps I can pick up the phone, free you up.
Thank you, Your Honor. I am doing federal court on the 1st, but I'll work with the parties to see if I can get called on the 30th, if it's actually gonna happen. I suspect, Your Honor, that when the factual issues come up in trial,
He's still trying. Here's his legal. He's still
there will
fighting it.
be some debate about whether these items should come in, because again, I'm not as plugged in as everybody here, but it just seems that the three topics don't go to any actual conspiracy theory, but I'm hoping that when the objections are raised, they may obviate my need to come on the 30th.
All right. That concludes the motion to quash the subpoena. Have a good day, sir.
Thank you, Your Honor.
We're going to keep listening, and I'm going to come back and ask Tim. I'm completely confused by that.
Right,
So
let's continue next with the continuation of the motion on the summary. Is Sergeant Corbett present?
Should be judge on me.
So Donna didn't get her hair done. Well, maybe her ponytail looks blonder, lighter, darker than the top of
And
her head.
also, so the record is clear on this matter, the motion to quash the trial subpoena is
Is denied.
denied as to all factual issues in which Mr. Marcus would have personal knowledge and can testify relevantly.
So Marcus didn't want to come, and he didn't work with the defense lawyers because Charlie could have waived the privilege. And it doesn't really have a privilege because they're co-conspirators. And that's why they charge conspiracy, because you can get co-conspirator statements in. That's a hearsay exception.
The motion, if you want, we can take up in the meantime, which
Sure.
was, they had objections to specific parts of the presentation as to hearsay and attorney-client joint defense privilege. We could go ahead and take those up now.
Go ahead.
May I approach, Your Honor?
You may.
Judge, it's changing the document, so it's based on what I have so far. So there may be more that comes up in trial. But based on what I have right now.
You've reviewed it all, correct?
What's that?
You've reviewed all of it.
I've reviewed all that we have as of now.
Right, go ahead.
So I think it's page 20. It's an email between Donna Adelson and Renee Griggs. And below it, it's in response to an email from Renee Griggs to Donna Adelson. It's hearsay.
What is this being offered for?
Judge, in that email, the defendant explains that she is stressed about her daughter not being able to relocate, that her daughter, I think, doesn't realize how much it will affect her life, Donna Adelson's life, their whole family's life if this doesn't happen. The comments from the counselor that are concerned about her stress levels, I think, just add context. That's what we would be asking for the whole email to be admissible for. And it's
So
also-
you're not offering it for the truth of the matter asserted, or you're offering it as a party opponent admission of some sort?
Yes, we're offering Donna Adelson's comments as admission by a party opponent, also a statement against interest about how stressed she is about her daughter not being able to.
Those are hearsay exceptions.
Family, if it doesn't
And the judge is kind of helping
The
her.
Therapists, or not therapists, life coaches' comments that are also contained in the email would only be there for context.
Very well, as to that point, Mr. Rauschenbaum, I will permit slide 20 if there is any limiting instruction that you wish to give concerning Mrs. Griggs' responses as only providing context to what the admission may be, that would be appropriate. But if these are party opponent admissions, they are permitted.
Judge, may I briefly just respond to be heard?
Go ahead.
The problem isn't Donna Adelson's comments. We don't have a problem with that. Those are statements against interest.
Yep.
And they're not confusing at all. They say exactly what they just said. The problem is Renee Griggs's email to Donna Adelson, which is hearsay. It doesn't give any additional context to what she says. You can understand Donna Adelson's admissions by her email alone.
So you're saying part then of this is just a response from Griggs to your client?
No, it's a chain, right? So it's a chain of emails between the two of them We have no issues with Donna's part of the chain coming in. The problem is Renee Griggs's chain doesn't, it's not confusing what Donna's saying. I can read it to you. She says exactly what they just said. So if you never heard what Griggs says, she says, I'm stressed about my son, but honestly, I'm more stressed about Wendy and what will happen if she doesn't get relocation at the June hearing. Her life will change drastically if she has to remain in Tallahassee, and so will ours, and not in a good way. But I'll tell you more about it when we talk. Hope your mother is doing better or at least stable, Donna. So if you just allow that in, which we don't have an objection to, that's a statement that Donna Adelson's making, you're okay. But
Does Griggs respond from there? Does your client respond from the response?
No, Griggs doesn't respond from there, but Griggs' email below is, hi Donna, I'm not sure, and I only have part of it, but I'm not sure if you're back from your trip yet or not. I had planned to check in yesterday. However, my mom was in the hospital and I was handling family stuff, so I was a bit out of pocket. More than anything else, I want to see how you're doing. It seems as though you have a great deal of weight on your shoulders. I could both hear and feel it on our phone conversation the other day. I'd really like to be able to help you shed whatever it is that feels so heavy. Please know I'm thinking of you and looking forward to our work together whenever you're ready. Take good care, Renee. I don't see how that isn't blatant hearsay without any exception. It doesn't, you understand again, their relevance that they just put it in for is exactly what Donna Adelson's email says, which we don't have a problem with that piece of it.
Ms. Dugan, what exactly context is being provided by Mrs. Griggs' first email before Ms. Adelson responds?
So the defense, I think, accidentally, when they read about, yes, I'm stressed about my son and my daughter, she doesn't get relocation and how all our lives will change drastically. That was Donna Adelson's email. The last email he read was from Ms. Griggs. In that email from Ms. Griggs, who's the life coach, she basically is just saying, I'm checking in on you. You seemed last time to have a great deal of weight on your shoulders. I'd like to help you. And that's when Donna Adelson talks about how stressed she is and how much their lives will change drastically. So I think that the life coach's email just gives Ms. Adelson's comments a little bit of context as far as explaining why she's kind of pouring her heart out there and explaining why she's been so upset.
How much further does this chain go beyond?
I'm not seeking anything more than this page. I think there is more of this chain, but this is the only page I'd be asking for.
I'll reserve ruling on this from now. I'll look at it again when I have my thumb drive and can review the slide in its entirety. Go ahead.
Judge, I think the next.
He's just an excellent judge.
Yeah.
He explains things, and when there's a question,
New slides on this,
he
but
says, I'll reserve ruling.
For ease, we'll go on the slides that you have, because it's the same issue.
We're going to recap all
So
afterwards.
slides 255. We don't actually have new slides on this. I apologize. It's slide 255, where Agent Corbett is estimating how long travel takes. We're moving to exclude that based on speculation.
Stugan, did Sergeant Corbett do any calculation or in some other way develop this information that can be demonstrated as reliable?
Yes, sir. So on this slide, we have actual versus optimal travel of Wendy Adelson on the day of the crime. The actual travel is based on the events in her call detail records, where it shows the cell towers that her phone is communicating with as she leaves her house and goes on her way that day from by the crime scene to ABC liquor store and up to lunch. That's based on call detail records. And also other evidence like an ABC receipt that she had that day. For the red dotted line, that's the summary of the shortest route. So we're saying this is the actual route versus the shortest route she could have taken from point A to point B, her home to where another liquor store is in the restaurant. What he uses to show travel time or miles is a company called, or a mapping company called Esri, which is, and if you need to hear more about it from Sergeant Corbett, he'll be here in just a second. But basically that is a software that Florida Department of Transportation uses for their mapping and mileage calculations. He uses this very regularly in all of his mapping and travel calculations and all of his presentations. And he knows it's reliable because several times he's tested it himself. He looks at where the map says the travel time should be in the miles, and he does the drive himself. So he's been able to personally test this several times, and it's been accurate. And what we have in this slide is, one is call records, the other is the summary of the shortest route, and it's literally just saying, hey, this is point A, this is point B, and this is the mileage according to Esri, and this is the minutes it should take. And it's twice as long as the actual, or twice as short as the actual route.
All right. The sergeant also will be able to testify as to his knowledge of this program, its use, and the fact that he is qualified to use this program.
Yes, sir, and I can ask him those questions today if you'd like me to, but he regularly uses this program and has knowledge of it, is qualified to talk about it, and has had personal knowledge of testing its accuracy before.
All right. On this issue, Mr. Rauschbaum, you're essentially objecting that either the sergeant does not have an accurate calculation or in some way misuses the program. What exactly are you getting at?
May I have one moment, Your Honor?
Go ahead.
So, by the way, right now they're arguing over this 329-page PowerPoint. What's really interesting to me is that they said they have new evidence from this latest seizure.
And you know what? We'll withdraw the objection.
Very well.
Rather
Let's move
cross
on.
on it. Judge, the next one, and let me just confer with my co-counsel for 1 second.
Go ahead.
And they were just arguing about call details related to Wendy's drive past Trescott, which could be very damning. Donna doesn't look too happy about this.
Judge, the next one is page 318. Some messages between Charlie Adelson and Donna Adelson. Charlie Adelson's messages are hearsay, and they're not in furtherance of a conspiracy.
Response, State.
Yes, sir.
If I could just give you the date of the messages too.
Go ahead.
The date is August 2nd, 2016, which is after the arrests of Sigfredo Garcia and Luis Rivera.
Stugan.
In the motion, defense also objected to this on the basis of joint defense privilege. Is that no longer being argued?
It's not that. We're the document we objected to on behalf of joint defense privilege is a, hold on, let me just double check. Is a different one, and we're going to withdraw that objection given the court's ruling earlier today.
Okay.
This doesn't have to do with that because it doesn't mention
This
Mr.
is just
Marquez.
hearsay. Okay.
This is just hearsay.
All right. So, Judge, on page 318, what we have are co-conspirator statements. This text message it says, this is from August of 2016. So this is going to be after the arrest of Garcia and Rivera. It says, from Charlie Adelson to Donna Adelson. Did you see in the paper where the state star witness that rented the hotel room is a convicted cocaine dealer? Maybe those guys were just up in Tallahassee buying drugs and just in the wrong place at the wrong time. Maybe the coke dealer did it because Danny didn't pay for his drugs, just like he stiffed everybody else he did business with. This whole thing is just crazy. Then Donna Adelson goes on to say, I didn't see which paper. Charlie Adelson says Tallahassee Democrat. Miss Adelson says, wow, I've stopped reading everything. Charlie Adelson says, the guy admitted to selling them cocaine and hanging out with them. And Donna Adelson says, OMG, exclamation point. Our argument would be that this is co-conspirator statements. This is nothing more than co-conspirators celebrating another possible explanation that does not involve them for this crime. They are theorizing about another possible explanation for Dan Markel's murder. And this is showing just their theorizing and celebration of something that doesn't involve them that could explain the murder.
Any response?
I just don't understand it. I mean, it is, I mean, I can show you the text messages in its entirety.
Bad answer.
To bring it up, but that's not what's happening.
You never admit that.
I don't even.
I'll review it with my thumb drive as well when I go through the slide deck. The problem, Ms. Dugan, that I'm drawing with this, the communications do not have to be so overt as to saying, you know, we're hiding the gun here or something of that nature. But them essentially mocking, I guess, the drug dealer or the fact that someone else has been arrested in furtherance of their conspiracy. I guess flesh that one out for me a little bit more.
Well, also, I mean, their defense is that they were extorted. And this message pushes back on that. At the time this text was sent,
Don't speak over each other.
Garcia and Rivera had been arrested already. So Donna and Charlie Adelson would have known the people behind Dan Markel's murder. And now those people are behind bars. And now, so why, if they've been extorted by these people for the past several years, why are they theorizing about another possible explanation for this murder? They know what happened to him. Those people have been extorting them for years and they're arrested. Why are they now trying to say maybe he was killed by a cocaine dealer for stiffing him? Why are they theorizing and celebrating something that doesn't involve them?
All right, so I follow your logic. You're not offering this for the truth of the matter asserted, but rather to rebut any theory the defense is planning to present about a extortion conspiracy of some sort.
Right. Yeah, I'm not offering it to show that the state star witness was a cocaine dealer. Maybe Dan Markel was killed by a cocaine dealer, or that's what Charlie Adelson actually thought. It's to push back on extortion.
As to the basis of which it's being offered, Mr. Rauschbaum, what is your argument?
The key is you got to look, and I'm happy to hand it up to you. You have to look at what Donna Adelson says. She doesn't say any of that. She's asking what paper, and I don't know what you're talking about. So it's Charlie Adelson's statements after the conspiracy, the alleged conspiracy, after the arrest, after the murder, and Donna Adelson doesn't respond in any way to what he's saying. She doesn't have a clue what he's talking about.
As to this slide, I'm going to reserve for now. I cannot ask you to show your defense or what you plan to argue, but ultimately, if any way, if it comes down to your client was relying on the statements of Charlie Adelson in some way concerning her behaviors and how she conducted herself and whether she in fact knew of the extortion, if the state plans to rebut the extortion theory of the defense, it is permissible as to that basis, but not for the truth of the matter asserted. If a limiting instruction needs to be given, it will be given as to that specific slide. You may continue.
Rauschbaum lost that.
Honor, I don't have a page number. Let me see if I can figure it out.
You got a lot of work after this, Tim, to explain this stuff.
It's very
We'll go.
small writing, and it involves text messages between Donna Adelson and Wendy Adelson after Charlie Adelson's conviction. Again, the text messages by Donna Adelson are fair game, but the text messages by Wendy Adelson are hearsay. And
Response.
the timing of it is critical. It's after
You're going to say co-conspirator
the
statement,
verdict.
even though she's just an unindicted
Hours after the
co-conspirator.
verdict in Charlie Adelson's case, so I'm not sure how it could be in furtherance of a conspiracy.
Stay.
So I think that and we may be able to come to an agreement on this. I think that I'm going to, there's several messages between Wendy Adelson and Donna Adelson in this chain. I would only be using from when Donna Adelson says, prayer hands, you shouldn't have to pray. He's telling the truth. He protected his little sister for years. To your brother protected you for years, now you're not guilty. I wouldn't be offering anything after that. So I think the only thing Wendy Adelson says in the meantime is, I love you, call me if you can.
If that's all, then we're okay with that.
How about that?
The next one is page 324. So
We can come to an agreement on this one too.
we're on a roll, Your Honor. So you're not using.
Do we need me any further? Call it a day?
I'm not going to use that one in the presentation.
Okay.
I tried to give them all the things that I could possibly use and have tried to whittle it down some.
Just to be clear, that's the Cellbrite with the website pages.
I will be using the website page for the non-extradition countries, but not the emotion.
Okay, we're good. That's all I have for now, Your Honor,
Very well.
on this issue.
As to slide 20, I will review the entire email chain and then make a ruling on it. Is Sergeant Corbett here?
Yes, he is.
Here we go. Chris Corbett.
You can go ahead and step down. So we can take
See, Dan's growing his beard back.
Yes, he is. Wow, some interesting things coming out this morning. We will recap it with the great Tim Jansen right after this hearing. And I was confused about the David Marcus stuff, which I have a lot of questions for Tim about. And if you guys have questions, as soon as this hearing is over, put your triple Qs in there for Tim, and I'll go through what we've been watching.
There goes Chris.
Sergeant, please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth? I do. You may take your seat. Thank you, sir. Mr. Dugan, I will allow you to inquire. The only thing that I would ask is that you hit the points that essentially were at issue in the last hearing. If there's other examination you have for the sergeant, you certainly may get into that as well.
Okay.
You may inquire when you're ready.
Thank you.
Now's a great time to hit the like button and subscribe if you like the content. Like and subscribe. Please. Pretty please.
All right. Sergeant Corbett, can you tell us your name, spell it for the record?
Certainly, it's Christopher Corbett, and that's Corbitt.
Okay. I know you've provided testimony a lot of times in this court, but just for the record, can you tell us where you work and what you do there?
Certainly, I'm a sergeant with the City of Tallahassee Police Department, and I supervise the technical operations unit.
Okay. And we're not going to be asking you for any opinions today, I don't believe, but just for the record, have you been qualified as an expert previously in the field of historical communication records analysis?
I have, yes,
And about how many times?
118.
He knew how many. 118.
Thank you. All right, so I want to go through a few different things that we see in your summary quickly, or types of things. One is going to be call detail record summaries. The next is going to be the plotting of location. The next is going to be, I want to touch on your route, something that came up earlier today. And the next is going to be emails and texts. For summaries, in this case, did we receive phone records for Wendy Adelson, Charlie Adelson, Donna Adelson, Harvey Adelson, Fredo Garcia, Catherine McVanwell, Louis Rivera?
Yes,
And did all of those phone records come from each party's respective carrier or phone company?
they did, yes.
Were each of them accompanied by a certification of business records?
They were, yes.
Are the phone records in this case voluminous?
Yes.
I mean, about how many pages are we talking about? Or just, I mean, hundreds, thousands, something like that, ballpark?
Ballpark is in the thousands. Just one set of records for Charlie Adelson is 4,400 pages, PDF pages. There's probably around 190,000 records that if you put to pages, approximately maybe 8,000, and that's, I think, on the low side.
In the summary that you prepared for the state and a copy has been given to the defense, which is the same copy that you were deposed on a couple of weeks ago. In your summary, were you able to narrow the parties' communication events by focusing on what law enforcement sees as significant days in the planning and execution of this murder?
Yes, I was.
Now, in the presentation, do we see call detail records summaries of communication between the parties?
You do, yes.
All right, I'm going to mark this as states 1. I've shown it to defense counsel. This is just is this an example of one of the slides that shows the call detail record summary?
Yes, it is.
Okay. And if I could publish to the court. Thank you.
Is there any objection to this exhibit?
No, Your Honor.
It is admitted as a part of this motion hearing.
Thank you. All right, so in your presentation, do we see several call detail record summaries, just as we saw in Exhibit 1, throughout the presentation for the parties' communication on significant dates in the murder?
Yes.
All right, is Exhibit 1 an image of how those look?
Yes.
Is that how they look, though, when you get them from raw records from the phone company?
No.
What do you do to make them easier to read and put them in that format? How do you do that?
First and foremost is assembling all of them together into one database or one pool of information. We will assign names or subscribers to the numbers so that we can recognize which party is speaking with which party. We have to evaluate each of the events to determine if they are valid communication events or if there may be routing events or voicemail events, and those may or may not be included. We would remove duplicate events. In a summary like that, if two parties or two subjects are speaking to one another, we would have both of those events. From one party's record, it would be outbound, the others would be inbound. So we would eliminate one side of that so that we could show that it was one communication between the parties, and then it would be assembled in something that's much easier to understand and read, which is the format that you had in your exhibit.
After each one of those call summaries in the presentation, or after most of them rather, are there slides that show photos of the parties with arrows depicting the communication and then showing who communicated with who, the time that happened, and the amount of time they spent on the call?
Yes.
Okay, and what I'm going to show you, or what I'm showing you, I'll label as states 2. Is states 2 how those, an example of how those, I guess like a chart of the phone communication looks in the summary?
Yes.
All right, this time I move states 2 into evidence.
Any objection?
No objection.
States 2 is admitted at this time.
May I publish to the court at this time?
You may.
Now this chart with the heads that has the data about the communications, are all of those charts that appear in the summary, are all of those based on the data that we see in States Exhibit 1, the call summary? So are they based on the call summaries for each of those specific charts?
They are based primarily on call summaries. Some of those would also include maybe text messages from another source, an iCloud return or a Cellbrite report. There may be calendar entries and things like that, primarily from the call detail summaries.
Okay, meaning that that's going to track a communication, whether it be a text or an email, that occurred between the parties.
That's correct.
And then you're saying that some of the charts with the heads and the arrows, when it contains the content of a text, that content would be from a Cellbrite report.
It could be, yes.
Okay. Regardless of whether it was from a Cellbrite or from the call detail records, is all of that communication in those charts from voluminous records, whether it be from a Cellbrite or from a call detail record from a phone company?
Yes.
For some of the communication events, I'm now going to move on to the location data. For some of the communication events in the call detail records that you told us about are these voluminous records from the cell phone companies. Were you able to determine location data for some of those events?
Yes.
All right, and I know you've given the court explanations in the past of how you do that. Judge, do we need to talk through that today?
Just briefly, so it's
Okay.
part of the record for the motion hearing.
Thank you. Would you give us a brief summary of how you do that
How I determine locations?
from call detail records? Yes.
So the call detail records themselves will generally contain, for most events, the location information in the form of the cell site or cell tower that the handset is communicating with for that particular event. From that, either directly in the records or from another key or cell site database, we would be able to determine the location of that cell site, where it physically is, plot that on a map, and then start to make some determinations about location. Generally, historical cell site analysis is about inclusion and exclusion. Given locations, places, times, and ask if a handset could be consistent with being at that location based on the cell site that it's communicating with, or inconsistent with that location. In addition to the cell site, we're also generally provided a side or a sector of a cell site. Most of our cell sites are broken down into multiple sides. And so that helps us kind of further narrow down where a handset may or may not be.
How does your specialized training allow you to determine the location of a handset or the distance from a cell site of a handset that a layperson might not be able to?
There's obviously a significant amount that goes into that. First and foremost, locating the cell site, determining the accurate sector or side, determining the width of that sector or side, how many degrees or how far across on a clock, so to speak, that sector might cover. Evaluating adjacent cell sites or nearby cell sites to determine what the appropriate effective coverage area of that cell site may be, taking into consideration topography, buildings, bodies of water, other things that may affect that radio signal. And then again, ultimately determining if I believe that a handset could have been at a particular location at a particular time.
When you determine, or when you are able to determine location of handsets, do you plot the cell sites on a map showing the cell sites, the time that the phone was communicating with that cell site, and the sector that they were communicating with?
Yes, sometimes we don't need to be as granular as the sector, and so sometimes we only plot the cell site itself. That may be good enough for the point, or there are times, yes, that we will indicate the sector as well.
Okay, and do we see those maps throughout your summary?
You do, yes.
All right. Do you use other things besides just call detail records to help you determine the location of a handset or who may be operating a handset at the time of a certain communication?
Yes.
Okay. In this case, did you use, let's start with, are there some examples of text in this case between the parties that helped you form an opinion on a party's location?
Yes.
Okay. Are some of those examples, if Charlie McVanois and Catherine, I'm sorry, Charlie Adelson and Catherine McVanois are making plans to meet up, and do you help, or do you look to that text message to help you determine their location when you then look at the call records and maybe see evidence of a meetup?
Yes, absolutely.
Okay. Or if you see a text message that says outside your house, can that help you determine a party's location when you're looking at the call detail records to see if their location is also consistent with being outside the person's house?
Yes.
In the summary, we also have, in addition to texts that have location data, we also have traffic tickets, car rental agreements, GPS pings of a rental car, premier gym still shot from footage, bank records of Rivera showing a picture of him at an ATM. I guess were some of those, I guess like a bank record, could that be part of a voluminous record as well?
Yes,
Some of those arguably not part of a voluminous record, like a traffic ticket or a rental car agreement. Would you agree with that?
sure.
Okay. Why were those included though in your presentation? All those things that I just named, in addition to the text with location?
Again, the cell site analysis is about locations and times. So, for instance, the rental car agreement for the first rental car provides a location and a time. It's an address of the rental agency and a time that the car was rented. So this allows me to take that location and time and compare to the call detail records. I can look at the locations of the involved parties to determine who was present, who drove to the rental car location, who did not. The citation afterwards, the location of the citation tells me that Mr. Garcia was in a different location than Ms. Magbanua, because we don't have Mr. Garcia's cell site locations in that time frame. So the location of the traffic ticket helps me understand that after the rental, he went somewhere different than she did. Helps me understand that at the time of the rental, where other parties were. Mr. Rivera was still at his home. Mr. Adelson was nowhere near. So we can determine again who was present, because that rental agreement gives me that location and time to compare records to. It's also the type of event. So it's a, picking up of a rental car. And so as we look at the call detail records and who may be communicating with who in that time frame, understanding generally how car rentals are conducted, knowing that Mr. Rivera or Mr. Garcia ends up with the vehicle, Ms. Magbanua takes him out there. It's presumable that they're both in the car together heading to that event. So I don't expect really to see communications between them, nor I might not expect to see communications between Ms. Magbanua and Mr. Adelson, because she would be in the company of Mr. Garcia. And then I know the date and time that the rental actually happened, and I would from that deduce when they separated. And then I start to see communications from Ms. Magbanua to Mr. Adelson. Because now, again, based on how a rental car generally happens, she has dropped him off, he has the vehicle, and now she will be by herself in the car and free to communicate. So all of that together goes into the analysis, if that helps.
Okay. Does the documents that you just spoke about, along with the other car rental agreement and traffic ticket, GPS ping, the Premier Gym footage, the ATM picture, do those documents help you determine cell phone location and help you form your opinion on where the cell phones are and who is using them and put the communication around them in context?
Yes, they're all locations and times that I can compare the records to. It's a validation of the records themselves. When I see someone in a picture or a video, I expect that their handset locations would be consistent with that. And if they're not, then there was an issue. In this case, they are consistent, so that's a validation of the records themselves. Yeah.
Okay. I was briefly going to touch on the routes, but now I'm remembering that objection was withdrawn. Is the court requiring any questioning on the software he uses to route? Okay, thank you.
You may lay any record, though, you think is necessary.
Okay. At this point, I don't think any is necessary, but if it comes up later, we can. Emails and texts are the next things I wanted to touch on. In your presentation, are there several emails involving statements by Donna Adelson?
Yes.
Were all of the emails provided by Google, which is the company that Wendy Adelson and Donna Adelson use to service their email?
Yes.
Does that contain a business record certification?
It does, yes.
Now, why were the emails included in this presentation?
They were included to illustrate the content, and as far as potential motive or events that were occurring at particular times during the
Okay.
investigation.
Do the ones that were chosen involve Donna Adelson's interest in the custody battle and motive in this case?
Yes.
Are the amount of emails in this case from Google voluminous?
They are, yes.
About how many emails would you say that there are?
Wendy Adelson's account has over, I believe, 87,000 Donna Adelson's account is over, I believe, 57,000 individual emails.
Okay. And I'm just looking for a ballpark here. In your draft of your presentation, the same one you were deposed on, about how many emails did we send to defense with emails that these are of interest to us and we may use in your presentation?
No more than 25.
Okay. Since then, have we been able to kind of whittle those down to a smaller number?
Yes, we have.
Maybe 5 or 5 to 10?
Definitely less than 10, I think 5 or 6.
Okay. But despite how many we use in our presentation, are all of those from voluminous records?
They are, yes.
As far as, we also have several text messages in your presentation that don't have anything to do with location. Earlier I asked you about texts that had to do with location. Like, let's go to your house tonight, or outside your house, things like that. Are there several texts in your presentation that are from Charlie Adelson's iCloud or the cell rights from the phones seized in this case that don't have anything to do with location?
Yes.
All right, not going to go through them all, but do some that are going to be included in your summary, do some involve Donna Adelson's interest in Wendy Adelson's custody battle and venting to Charlie Adelson about that?
Yes.
Are there some that push back on a possible extortion defense?
Yes.
Are the total amount of text that we have in this case from Charlie Adelson's iCloud or from all of the parties' cell rights, are those voluminous?
They are, yes.
About how, I mean, ballpark, how many?
I believe from Miss Adelson's phone, there's over 10,000 WhatsApp chats, 20-some thousand instant messages. Charlie Adelson's iCloud account is, I believe, well over 280,000 messages. Another probably 10 or 20,000 text messages. They're kind of categorized separately, so we're in the hundreds of thousands of messages.
Okay, and thank you for clarifying that. So when I say text message, I mean any message communication as far as text, instant message, or WhatsApp. So thanks for clarifying that. And so that we've gone from, I mean, and how many would you say we've included in your presentation to show the jury at this point?
I haven't counted them. There may be less than 20 chats with, maybe, I would probably say less than 50 actual messages. But again, I have not tallied those up.
All right, but from tens of thousands to less than 50?
Yes.
Okay, and those are all speaking to specific issues in this case?
Correct.
Okay. Those are all my questions I had for him, Judge. If you wanted to, I can address any specific slide or document that you feel I didn't ask enough about that you need more of a record on. Okay, thank you.
No need. Mr. Rauschbaum, do you have an examination for the witness?
Very, very briefly, Your Honor. So, good morning.
Good morning.
So you testified that with regards to these detailed summaries, there's thousands and thousands of pages, right?
That's correct.
Okay. But on the days that you're using, so in other words, I think Ms. Dugan showed you Exhibit 2, where you're doing the arrows. On those days, if you look at the call summary, it's less than 5 pages, right? Mostly 2 pages on most of those days.
For those days, the summary that you have may be a page or 2 pages. It took a significantly greater number of pages to get down to those 1 or 2, because again, if there's 5 or 6 subjects in that one summary, well, that's 5 or 6 subjects worth of records. And their records for a 3-day, 5-day period, maybe 20 pages each. So there's 100 pages to work down to get to just the unique communications that populate that 1 or 2 that's in the summary.
So let's get a little granular, okay? So you have one of those days is July 18, 2014.
Yes, sir.
Okay, and you do a summary of that day. If you took all your call records of that day, would it surprise you? All of them. If you took the call records for Charlie Adelson, everyone you got, would it surprise you that it's under 15 pages?
For one day to be under 15 pages, it would not surprise me.
Right. Well, I'm telling you, it's under 12 pages.
Okay.
That surprised you.
No,
Okay, so
No.
that's not that voluminous, right?
but that's 12 pages to get down to one. Right?
I get it, but I'm saying if you're putting in a document, in other words, if I use the emails as an example, or the text messages, Ms. Dugan brings up that there's 20,000 text messages, or actually 12,776 text messages. You can take my word for that. You're only using, though, let's say 8 text messages. I don't know what you're using, but let's say it's 8. How long are those 8 text messages that you're using? They're less than a page, right, each?
They could be, yes.
Okay. The emails that you're using, you've got however number of emails you're using here. Wendy Adelson's email account had hundreds of thousands of emails, I presume. Right?
Yes.
Okay, but each email that you're actually putting into evidence, do you know what the longest email is of the ones that you're putting into evidence in?
It would depend on how you format to print, probably not more than 4 to 6 pages.
Yeah, it's 6 pages, right? So the actual piece of evidence that's going to go back to the jury, which is the actual email, not the 100,000 irrelevant emails that no one cares about, but the actual document that's going to go back to the jury is 6 pages long, right?
I would agree with that, yes.
Right. So we're talking about, and Ms. Dugan uses the word summaries, but these aren't summaries, right? These are just taking pieces of evidence that are already going to be in evidence and sticking it into a PowerPoint presentation, which is a way of persuading, right? A demonstrative, not a summary.
I would object to argumentative.
Sustained.
Okay, I'll move on. With the location data that you're talking about, just centering on Donna Adelson, and I don't know if you have your records up there, so I'll just show you a page. Okay, and we can mark this as Defense Exhibit 1 for purposes of this hearing. This is page 271 of my version of your insurance change. You'll know it. So.
Yes, sir.
Okay. Judge, may I approach?
Right.
So your expertise in doing this page, am I right that what you're basically doing is you're taking Donna Adelson's call record, you're seeing when there's an event, you're looking at what location on the call record the event hits, you're then going to a map that AT&T provides you, because it's AT&T in this case. You're then looking what the longitude and latitude is on that map, and then you're just plugging it on that piece of paper, right?
That is part of what I do, yes.
On that piece of paper, is that what you did?
You need to say the Sergeant.
No, I don't think so, sir. Again, to start that, I have to go through, and this is combined. This is Donna Adelson and Harvey Adelson's records. So it's 2 sets of records. So I go through the records to find the relevant time frame, and there's 3 data sets for each set of records. There's voice calls, there's data sessions, and there's text messages. So I isolate out each of those 3 data sets for the 2 sets of records. And then I have to evaluate those records for what I consider to be valid location information. And so a number of records are eliminated based on my understanding and knowledge of AT&T records. A lot of those locations are eliminated so that I have valid locations to plot. So from that, each of the locations in the records have to be verified against a records key or some other database for me to make sure that the information provided in the records is accurate. And then that is plotted onto a map. And then from that, some estimation or determination about where the handset was during those events can be made.
Okay, let's try to simplify that. I know you like to make it a little bit more complicated than it is. But when you say you eliminate events, you eliminate them, for instance, when it says 0 seconds, correct?
0 seconds could be a factor.
Right? Why else do you eliminate? What duplicates, right?
In location information, the duration may play into the validity of data sessions. In particular, with these records at that particular time, not all the locations contained in the data sessions are accurate at the time. So I have to go in and evaluate each one of those to make sure that they are the correct usable locations for that. And I guess I'm not the one to determine how much expertise that takes, but I believe that it certainly requires it.
Well, on that piece of paper, which is all Donna Adelson's, everyone that relates to Donna Adelson looks like that, okay? So on that piece of paper, would it surprise you that all you needed to do for that piece
I
of
would
paper?
object to relevance to what would surprise them.
Sustained.
Okay.
Please
I'll
re-ask your question.
rephrase it. On that piece of paper, you can see those times directly on either Harvey Adelson or Donna Adelson's chart. You see a call or a text message.
Yes.
You go and you look at what time it is, right? It says 8:15 next to the call.
Correct.
And then to the right of it, it gives you a longitude and latitude
It does.
for each of these. And then you take an AT&T map and you plug in that longitude and latitude, which is what you did, right?
Well, I don't take an AT&T map. I take the mapping software that we use, the Esri mapping.
Fair enough. You plug in that longitude and latitude and it spits out a point to put a dot on a map, right?
It does.
And so even though it can be difficult, I'm not saying that there aren't examples that are difficult. In the ones that you're doing for Donna Adelson, it's on these pages. It's as simple as that. It's as simple as looking at the data, plotting it in, and doing dots.
Again, I don't know that I'm the one to quantify what is simple or difficult, but I will tell you that if you took her records and you plotted every event in that time frame, you would be plotting some incorrect locations. So it at least requires the recognition of valid locations at the very minimum.
So tell me, on that piece of paper, what events were invalid that you got rid of? Because I don't think there were any invalid on that piece of paper. I don't think there were any other cell site data that showed up. I think those are the only ones that showed up.
In that sequence, that
Yeah.
travel sequence in those
Tell me
period
what
of
you eliminated.
time, there are a number of data sessions, and I would have to be looking at the records themselves, that are continuous data sessions. And so they show locations, particularly from Mr. Adelson's cell phone, as I recall, of data sessions that originated at his office. And those data sessions continue to show the original location, even though the times increase. And so
You're talking about Charles Adelson.
I'm talking about Harvey Adelson.
It showed him at his office on that day,
It did, yes.
on July 18th?
As I recall, that
Are you
I
sure
don't-
about that?
I don't want to say office. There are, if I can look at the records, there are data sessions that originated earlier in the day that continue to show the original location.
Okay, let me ask you a more simple question. On the actual exhibit that you're using, which starts at 8:15, I think, it plots, I think, 4 locations. On those 4 locations, were there anything that you had to eliminate in between those 4 data points?
I don't recall specifically. I could look at the records and tell you, but I do not recall if there were other things.
Or
in
do you
that
have the
time.
records in front of you?
I have my laptop. I could pull them up. It will take a minute.
Go ahead.
So Rash questioning Sergeant Chris Corbett about the records here, and he's now wanting to pull them up related to where Harvey was, I guess, the day of the murder.
My memory serves me. It seems like this line of questioning is Mr. Ashbaum's trying to inquire into his level of expertise and why does it require an expert to do this type of work. Did the court already, I believe the court already ruled at our last hearing that he would be able to testify as an expert, form an opinion as to locations of cell phones, all of the things we would be offering him for in that purpose.
That ruling was made. Ultimately, is this going to an opinion that he is not permitted to give in some way, Mr. Ashbaum?
No, I mean, I'm trying to show that there's no expertise in these particular documents. There might be in showing where Sigfredo Garcia's timepiece was, but that there is an expertise with regards to Donna Adelson's. And I'm going to using this to show that the documents that he has chosen here, or that the state has chosen for him, that it's a demonstrative. It's not a summary exhibit as iterated under the Florida statutes. Again, we're not arguing that the demonstrative can't be used, and we're not arguing that the underlying documents can't come in. We're arguing that his presentation is not a proper summary, but is rather a closing argument that shouldn't go back to the jury.
And to that point, I'll permit it, but let's not have a full cross-examination of the witness that goes beyond the issues as to the admission of the evidence.
Fair enough, Your Honor.
So Dan doesn't want to get into a fight with Chris Corbett on this. He'll lose every time.
Yeah.
And it just makes him look foolish, some of the things he's arguing. And when he
Professor-
tries to interject his own beliefs, that's not admissible what he believes. And there should be objections to that.
The reason our sound is better is Space Coast. The guy's an audiophile. They're arguing over communications.
Sergeant Corbett, if it's difficult to pull up, we can move on too.
Not difficult. It will be a little time consuming again.
Let's move on. I think we've made the point. Sergeant Corbett, these emails and these text messages that you pulled, how were they chosen?
I did not choose them, no.
Okay. Who chose them for you?
They were ultimately chosen by the state attorney's office.
May I have one moment, Your Honor?
Go ahead.
That's all Dan wanted. He could have done that in 5 minutes.
Can you redirect
But
examination?
he wasted time trying to show he's smarter than Chris, which he didn't do.
No. Professor Patuto, who's been on the show, is a law professor in Nebraska, said that
In addition to the argument that was made at the previous hearing, does either party have any additional argument to offer before the court rules?
Very briefly. Or did you want the?
Whoever's ready. You are the proponent, Ms. Dugan, so you get the first crack.
All right, so we heard about several different types of items that are in the summary. The first is the summary of CDRs, and the example of states 1. We heard that those are pulled from voluminous business records for certain periods of time. Then we saw the charts that are basically a visual depiction of that communication that's but in a more digestible format for the jury. It's based on data from those call detail records, from the voluminous business records, and also from voluminous records in the Cellbrite. The only thing in the chart that is from Cellbrites would just be some charts have contents of text messages in there. All the rest are going to be calls back and forth with the time and the person making the call and the person receiving the call. But all of that information is based on the data, and we can't just give the jury all of these cell phone records and say, even if a certain day is 16 pages across 3 sets of records, and say, good luck. That's why the summary rule allows us to pull this information, put it together in a digestible format for the jury. The second type are the maps with the cell site locations. These are summaries of the parties' locations at certain times that are also pulled from the voluminous cell phone records. The same records that the call detail record summaries and the charts with the heads are pulled from. Other items like the premiered surveillance footage, the tickets, the texts that talk about a person's location, the bank records, the car rental agreements. All of those things are in the summary because they help Sergeant Corbett form an opinion on who had the handset at the time and where that handset was located. And they help verify the call detail records themselves. Finally, we heard about emails and text messages. The emails are business records from Google. These are voluminous records. They are being testified to by a sergeant who specializes in communication records. He has identified and verified these as being from these accounts. There are thousands of emails. We found several emails, lots of emails that go to motive or go to the interest in the custody battle here, We're going to be using about a handful in the presentation. The same with the text. These are maybe 50 texts narrowed down from hundreds and thousands that show certain relevant issues from this case, whether it be pushback on extortion or other things. And these are all pulled, though, the emails and the texts that aren't location data is what I'm talking about. They're all pulled from voluminous records, and they're all a summary of evidence showing a relevant issue from those voluminous records. Thanks.
Thank you. Mr. Rashbaum.
Judge, you've seen their summary. Their summary is a closing argument. It's not a summary. It's a demonstrative. Our ask here is not a big ask. The underlying exhibits are going to go to the jury. They're not voluminous. The fact that there is a universe of text messages and they've chosen 10, 15, or 20 of them does not mean that they can make a summary of it. That's not how the rule works. They can put in the text messages, none of which, not one text message is voluminous in this case. Not one email is voluminous in this case. And by the way, the call records aren't voluminous because what they're going to put into evidence are they're going to put in the overall call records, and then they can put in, if they want, a subset of the call records. For instance, July 18th. They can put in those call records. They're literally less than 12 pages. Now, we're not suggesting that Sergeant Corbett cannot have a demonstrative that illustrates the issue, but to allow a 320-page document or whatever it's going to turn out to be, which is purely argumentative. I mean, they're taking text messages and homes and cell locations, and they're all making their argument of what it means, is precisely what the court in Pete Incorporated v. Vanguard 378 F3rd 1154 cautioned against. When it said, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence, care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. That's what they're doing here, Your Honor. They're putting a closing argument. They're trying to put his demonstrative as a summary exhibit of a closing argument to go back to the jury. That shouldn't be allowed. And so, Judge, we're not asking that a demonstrative not be used. We're not asking that the underlying documents don't come in, but we're asking that the exhibit be a demonstrative exhibit, that does not go back to the jury.
May I briefly respond, Judge?
So briefly, it will tickle my ears and we'll move on. Go ahead.
There is no argument in any of these slides. This is all data and information from the records. There's plenty of evidence in this case that is not in this presentation that would be in a closing argument demonstrative. This is not a closing argument demonstrative.
Judge, may I briefly respond?
Let me set my watch. It's 11:02 and 32 seconds. By 11:03, you will be done.
Argument is when you plot lines on a map and then you take a text message and you put it next to a house and you put it all together. That's argument. That's using data to make an argument. That is the definition of argument.
Within time. Thank you.
Your Honor.
All right. As to the rulings on this matter, the court has previously ruled that Sergeant Corbett can be qualified to testify to the interpretation of historic communication data. The summary will be available to the state as a demonstrative in front of the jury. Also, in researching this matter, I came across a recent case of the 3rd DCA dealing with summaries, which I believe has a relevant ruling to this matter. This is EJD Construction Contractors and Investment Corporation versus Preston, found at 306 Southern 3rd, 1053. And ultimately, the 3rd DCA held when a summary is accurate and not misleading, it can be properly admitted during trial. The summary may also include opinions by the individual preparing the summary, as long as the opinion is based on the underlying evidence and data that is admissible. To that point, the court will permit a summary to be admitted to the jury. However, the summary may include a page cross-referencing all voluminous records or state exhibits that Sergeant Corbett used in forming his opinion, his method of analysis, and the conclusions that he reached, or any inferences which may be properly drawn from the evidence. The summary is not to include any cumulative repetition of admitted state exhibits, and this is specifically going to matters such as the emails, text messages, videos, things of that nature. Any inadmissible information or any opinion the witness is not qualified to give. This is going to cut down the pages that actually go back to the jury, but a summary that is based on the voluminous records and exhibits and the opinion that was reached by the sergeant that is proper and meets the definition of a summary pursuant to 90.956 will be permitted. Any additional objection that needs to be raised at the time it is offered, the defense may raise at that point. The parties need any clarification on the ruling?
No, sir.
And just so it's clear, as far as the call records summaries, and I believe the arrow charts, those will be permitted as far as being in the summary itself. The location maps, that will be permitted as well. But again, all of the other matters that are not voluminous themselves, such as any emails, text messages, or videos, it can be cross-referenced as to what the sergeant used, but it will not be a part of what is admitted. The demonstrative itself, though, can be used as the state would like to use it. Ultimately, for that, if there are any inadmissible items that still need to be ruled upon, I believe slide 20 is the only one outstanding. I will give you a ruling on that matter before it is to be used even as the demonstrative. There are no questions. We are finished at this time. I will see everyone on Tuesday morning at 8:30, and we will begin with the jury selection process. The process will be, as we did in the last trial, going through the same 5 questions dealing with pretrial publicity and any hardship. The parties will be permitted to examine the prospective jurors based on the court's questioning. Anything that we need to address before we finish?
Judge, there is just one schedule.
The motion in layman.
And look, maybe trial will go quicker. I'm hoping it does, but based on what I'm seeing, October 3rd is Rosh Hashanah, the Jewish holiday. And just wanted to
I
see.
believe the court is closed on that day.
Perfect. And I'll sit down now.
I'm not going to make you work on a holiday, Mr. Rauschenbaum. Yes, ma'am. For Monday, let me go through that then based on the chart that I have with Lynn. If it's not related to this, then we're just going to finish up. We're in recess at this time. Have a good day, everyone.
Let's keep this up for a moment. And there goes the picture. It is out. Pool camera is done. You saw Dan Rashbaum speaking to Donna Adelson. That was a long hearing, probably about an hour and a half, hour, maybe 40 minutes. It's back up. You can see Donna in her purple jail jumpsuit, shackled at the waist. Leon County Detention Center. Rashbaum with a little smile. Alex Morris looking to help her. Her legs appear shackled as well. I'm not sure if they are. There's a lot. Yeah, we need the Tim translation. I got lost right off the top here. So let me just take this back. And please put in your triple Qs for Tim. Donna is walking out. Picture coming in, coming out. Donna being let out. She's going back right past Sarah Dugan to the Leon County Jail. And there you go. So what's interesting, Tim Jansen, they revealed today that there are new text messages from these devices that they seized after Donna's arrest, and text messages and other sorts of correspondences. So that's interesting. The first, it was, I guess, expected, but interesting nonetheless. And they even brought up a specific text message between Donna and, I guess, her life coach, which is sort of fascinating in and of itself. But this first issue today was a motion to quash the subpoena for Charlie's previous lawyer, David Marcus. It was denied. The state basically says that they believe the Adelsons at least offered to pay for some of Katie McBanawa's attorney's fees. Then there was, Tim, and help me out here, there was right off the bat talk about someone calling immediately after the murder about intending to call Detective Isom, and I got tripped up right there. Do you know what that was regarding, who that was?
Well, I didn't catch that point, but that wasn't the point on this Marcus subpoena, right? That was
Okay.
thrown in there, but it wasn't really ruled. So what the state did, they charged with a conspiracy, right? So anytime co-conspirators make a statement, they're arguing, judge, it's part of the conspiracy. And at the last part, you saw how Donna and Charlie were trying to come up with another explanation for why these guys might be up here because of a drug deal. That is an alternate theory, right? That's the alternate theory co-conspirators are coming
By the
up
way,
with.
did I understand that correct? Were they intimating or just flat out saying that Dan Markel may have
Yes.
stiffed drug dealers?
Yeah,
That's
that's what they said. It's derogatory talking like when they talk derogatory about Ruth and book signings. These people have no principles, right? It's all about saving themselves. So when you argue it's a conspiracy and these are co-conspirators giving an alternate theory, the judge was listening to that and then said, Judge, they're going to testify about an extortion. This is inconsistent to rebut it. Now you have a basis for the judge to let it in. And it just undercut their defense. This is coming in because it undercuts their so-called double conspiracy, because why would they be talking about them shooting them because of a bad drug deal when they knew that these people committed the murder, right? So so Dan and them ended up losing on this issue, and now they know that's coming in. And
so.
Marcus,
I mean,
who doesn't want to come, has to come now.
So just so I clarify this, if the defense theory again is this double extortion, and now they're communicating saying, well, these guys were they knew that they were being extorted, so they were obviously making this up. Then is that the idea?
That's exactly right. And when he said Donna didn't respond, if I'm Georgia, I say, well, you knew this wasn't true because you said your son told you that he got extorted. So when he says they were doing a drug thing and got robbed because Danny didn't pay him, why didn't you respond and say, hey, Charlie, I thought that these are the people that extorted him, killed him. Why didn't you respond? Isn't it true you didn't respond because you're making up this extortion thing? And that this whole thing was a plot, and Dan was trying to come up with an alternate theory before he came up with this theory at trial. It's going to undercut Charlie's testimony and Donna's, and it's admissible.
STS Nation, you guys are a lot smarter than I am. So, and I was asking Katie Kool-Lady this in a text message, but I just didn't catch it it was basically at the very beginning of the of this hearing where they were talking about if someone, and I don't know who that was, intended to ask Detective Isom, I guess it was if Katie McBanawa called immediately after the murder, and how would she have known to call Isom? If someone can clarify that, I'm not even sure if it was Katie McBanawa. Please let me know.
So here's the deal on that, Joe. They wanted to, because the lawyer called the investigator after McBanawa got arrested, wanted to find out if Charlie was arrested, right? He's calling immediately to see if Charlie's arrested. They're saying it goes to show a conspiracy of them to circle the wagons. And how would they know that Meg Bonner got arrested if it wasn't for this co-conspirators talking amongst themselves.
Interesting. I don't know. Sum that up for me one more time because I'm a little slow. So this is after Magbana was arrested, is what you're saying?
Yes, after Katie was arrested.
Then what happened?
Apparently, Marcus got contacted by somebody,
Okay.
right?
And that's Charlie's lawyer.
And he contacts Isom, right?
Okay.
To say, hey, do you have a warrant? Is there a warrant for Charlie? Now, the thing is, how would Marcus have known that she got arrested? How would they know that Isom is the investigator, but for these co-conspirators having a conspiracy, and he's trying to find out if his client got arrested? And they're arguing, Judge, it's a conspiracy, and it goes to prove the conspiracy because when she gets arrested, Charlie's lawyer immediately calls to see if there's a warrant for his arrest.
Yeah.
And then
Wesley
there's
John,
an
I think, by the way, I think Wesley's right about this. I think it was after, I think they said after Sigfredo and Luis Rivera's arrest.
Was it after their arrest or after Katie's?
I think it was after Sigfredo and Luis because I have that in my notes too.
Okay.
So
well, it's still the same. It's still the same. Because if that's even worse because he's farther away from Sigfredo and Luis, right? Why would he be calling to see if Charlie's arrested? Right? Because
here's
Sigfredo and Luis have no contact with Charlie.
Roxanne saying, Joel, Katie called David Marcus on May 26, 2016, before she was arrested. Okay. So now that's starting to make sense. By the way, I'll be the judge. Great question. Tim, many times it seems like Rashbaum argues his feelings over the law. Am I wrong?
You're not. And he does sometimes show some disrespect to the court in his arguments. And you see Sarah. Look at Sarah's very organized. Sarah knew what the issues were. She had her witness. She was organized. She had relevant testimony. And trust me, they've gone over that testimony with Corbett before they got there. So they knew what she wanted to present. She presented it in a good fashion. She even threw in there in your specialized training in her question, trying to get him to respond, and he did. And the defense didn't object. But she hit all the points she needed to. Voluminous records, thousands and thousands of records, that they were business records, so you can trust the records. And that we didn't argue anything. This is just documents to help the jury. Those are all things a judge wants to hear to allow something because they don't want to have a jury looking over 100,000 records to find 2 emails. You know, she was very good about it. And Dan was able to keep the opinions. It's probably going to get smaller, but it's still coming in. It's still going to be a summary. And he can make many of those objections he made in cross-examination rather than doing this whole motion that took an hour.
By the way, if you're enjoying the content, please hit the like button and subscribe as well, because we're going to be doing this with lunch lives and daily shows throughout this trial. We'll be covering it gavel to gavel. From Rosemary, and I want to get back, there's some other really interesting things. We'll go through this all right now. And reminder, Tim is coming back tonight at 7 o'clock. We'll have some time to digest all this. He's going to be joined by 2 retired judges, and one of the judges, I believe, was formerly a police officer, and they'll have a really interesting perspective on all this. But Rosemary Romero, saying that Donna and Wendy have so many emails, Tim, something like over 100,000 between them. Can the prosecution introduce new emails in the trial? I'm assuming that's a definite yes. The question is, I guess, is there the possibility that there's like a nuclear bomb text message here that's going to just destroy the Adelsons?
Well, we learned today that the whole extortion defense is going to be undercut by this email between them 2 talking about, oh, maybe they're robbing Danny because he didn't pay for his drugs. That's a killer to the defense. Absolutely a killer. If she says, I was told after the murder that they killed this guy, now you got to pay me, and I told my mom. Yeah. This whole conversation undercuts all that.
And let me ask you, how long has the defense known about this text?
I don't know when they got it, if they got this after Donna was arrested, or it was a part that was never introduced, was never going to be relevant because they didn't, remember, they didn't know about the double extortion until opening arguments for Charlie. So they probably didn't think of the significance of it until after that so-called. So timing is usually on the government's hands because once you throw up your defense, they've got resources to undercut that. And they got people looking, and apparently they've found something.
And what's so crazy is that Charlie said that Wendy, it was the first time she was hearing about all this was at his trial. I mean,
when he was flirting with her,
Oh, that's
his own sister, which is
Go
crazy.
there. I don't want to go there. Carol Renner, have any of those emails revealed if Wendy was involved in her ex's murder? I mean, Tim, the bottom line is we don't know what we don't know, but
That's right.
But let me ask you this: if the state has something else that's just wildly destructive to the defense, would we know about it, or would just Rashbaum and Alex Morris know? Would the public know about it at this point?
They would know about it, of course, and they're probably going to have to shift their defense. Trials are fluid, and while you might have one defense 1 minute, one witness can destroy that. So you always want to have a plan B. I don't know where this takes them now, because that email that they discussed this morning that's coming in just kills them, and it's going to have some indicia of reliability, so because Marcus was now going to have to testify about this conspiracy, about making the phone call. They're going to be able to argue, you see, all these people were together. And our theory is correct.
Yeah.
That there was an offer to pay her fees, right?
Yeah, I don't think Rashbaum won any motions today, but he kind of got with the PowerPoint that it's got to be a summary. Yeah, the summary is maybe the only thing here. Jade Roscoe, Tim, getting that text exchange in between Charlie and Donna Adelson about Sigfredo and Luis implying Dan could have been wrapped up in a drug deal feels like a big win. I mean, I just think that that's crazy hypothesis that the jury is going to see right through. So that is a big win for the state. Right?
That's checkmate. That's checkmate for the double extortion. Because how does Donna explain? How does she explain she didn't correct him and say, "Oh no, Charlie, I thought they were extorting you"?
So another thing that came up in this first part of this hearing, Tim, you got a little bit more time?
Yeah.
Are you good? Okay.
Yeah.
We'll move it along. Yendra, who's on the show last night, who's testified, she's a friend of Katie, my former friend, I guess maybe still a current friend of Katie, and testified in her trial. So who will flip first, Charlie or Donna? Tim, does this move the I don't know, the ball down the field when it comes to flipping?
No one's flipping. No one mentioned it. The judge didn't mention any plea offers. The judge just mentioned conflict. Judge goes, "I'll see you at jury selection on Tuesday."
Yeah, there you go. So Tim, the next part of this first part of the motion is again that the Adelsons possibly provided legal fees for other co-defendants, meaning Magbanawa. The FBI spoke to David Marcus about this. What's the significance of that? I mean, there was always this thought that maybe the Adelsons were funding her. This is not saying it explicitly that it happened, but it's something implying it could have happened. So where does this lie in terms of the way it plays out legally in the courtroom?
Now, remember, I don't know if you remember, but Judge Hankinson got involved in this and had a Nebbia hearing to determine who was paying the legal fees for Magbanawa's lawyers, because the state was concerned that co-conspirators were paying her legal fees. That's why she wasn't taking this plea deal that was so generous. And for some reason, they had a hearing, an in-camera hearing, and Judge Hankinson felt satisfied that actual money was not being paid by the Adelsons. There has been arguments and suggestions that the lawyers that represented Katie Magbanawa were paid very little or a less fee to try to do the case and may have been paid by a relative of Katie's, but took it for a smaller fee to handle the high profile case. But the fact that people were calling and called David about the possible fees is damaging, and it fits the conspiracy theory that the state believes was happening.
It keeps coming up, so I'll just have Tim put a bow on it here. But today's ruling by Judge Everett more likely prompt a deal for Donna? Is it possible that something comes up in the next couple of days?
No deal. There is no deal.
There you go. You heard that loud and clear. Okay. So there's another part to this first part of the hearing, and that is Tim Jansen, a text message, again, between Charlie's previous attorney, David Marcus, and Charlie, his client, about the attorney himself, Mr. Marcus, bumping into Katie Magbanawa outside of his law office. And it was, I guess, there was a question of coincidence. Krista Cost, who was her attorney as well, has an office in the same building. And then the whole issue of Charlie waiving privilege came in. Can you break that down for us?
The fact that he ran into Katie Magbanawa is not privileged in any way, unless he spoke to her. Any words he spoke to her might be privileged. You know, just because they have one lawyer doesn't mean they can't talk to another lawyer about another lawyer hiring somebody.
But what is the significance of them just bumping into each other? I mean, it's...
Well, I think you're right. I think the offices are really close, or maybe in the same building. Mm-hmm. So it wouldn't be abnormal at lunchtime if he was leaving and he recognized her and they knew the people and general, hello, how are you? I don't think there's a problem with that. Marcus is a smart lawyer. He clearly didn't want to come testify here, and he was actually trying to argue the motion for Rash, and Rash wasn't being successful. And he kept trying even after the judge ruled, saying, I don't think it's relevant, Judge. And how can this be? And the judge wasn't going to hear any of it. It may be relevant for co-conspirators and to give context and for impeachment. So he's going to come and he's going to testify. No lawyer wants to testify in a courtroom.
And then did you follow the whole issue with Charlie waiving privilege, that he did not waive his privilege? So how does that impact Marcus's testimony?
Yeah, that's a problem. The client can waive the privilege, but that has so many dangers. Because courts don't let you waive privilege for this, but not waive privilege for everything. That would have opened Charlie up to cross-examination. He could never say attorney-client privilege because you can't waive it and so courts, if you waive it, you waived it. Now you're subject to cross-examination and you can never claim privilege. That's why clients never waive privilege. That's probably why Dan didn't have Charlie waive privilege for this little issue, because it opens him up. So I can see them not waiving it because of the jeopardy that would put Charlie in.
By the way, just from a calendar standpoint, they said that Marcus would testify September 30th. So this is going to be, I think, a longer trial than Charlie's. Charlie's lasted 8 days, but if we go to September 30th, that's jury selection starts this coming Tuesday. Tim thinks openings could happen as soon as Thursday or Friday. It would go for, I guess, like 2 full weeks if this calendar is right, because we're on September 12th today. So it's gonna go longer, I think, than Charlie's trial by possibly a good couple of days. Wesley John Holmes to Tim Jansen. I missed a bit of this. They didn't really discuss Rob Adelson. So what's going on with that, Tim? Do you think that we hear from Rob Adelson? Does he testify at this trial?
I think the judge must have told them at sidebar that we'll discuss this. Let me review it. We'll discuss it before opening statements, and they can do it in an early morning. Normally when you have trial at 9 o'clock, the lawyers have to be there like at 8:15 and they discuss issues. He'll probably give them an answer before the opening statements, and so that they can plan the travel for this witness, because if it's not going to be allowed, then they don't want to make this guy come and spend money. So I expect we're going to hear about that before the trial starts.
By the way, Carla D, I've just come from watching the episode with Ryan and Yinder. That was last night's show. anyone has not seen it, do yourself a favor with the OUR, the British spelling, and watch it, or Canadian, or Aussie, or New Zealand. Justice for Dan M. I'm so mad. I'm gonna look at the irony. She's gonna miss the trial because of jury duty. Sorry about that, Sherry. Tell them you're.
Tell them she's already on jury duty and she's
Yeah.
watching this case.
Tell them you're a lawyer for Court TV. Make something up. Tim Jansen, can you briefly explain the Tallahassee grand jury process? Must there be a grand jury first to arrest Wendy? I mean, everyone's chomping at the bit. If she's arrested, Tim, when would this happen? How does this happen? Et cetera, et cetera, et cetera.
Well, remember, you don't have to be arrested. You don't have to be indicted by a grand jury to arrest somebody. Donna was not arrested by a grand jury. She was arrested by a warrant signed and then ultimately was indicted by a grand jury. They can charge her with second-degree murder, conspiracy to commit murder, whatever, and just have her arrested based on a warrant by a judge being signed. Not that I'm saying that's going to happen, but no, you don't have to. But to get a first-degree murder, it has to be an indictment by a grand jury.
Can Tim give a win or lose for both sides today, Tim Jansen?
Well, if you're counting the scorecards, Marcus is going to have to testify. Corbett's going to be able to testify as an expert. The summary is going to be admissible, but it's got to be pared down and taken some things out. And the biggest loser of all was this email's coming in that's going to undercut the double extortion defense. So I say it was not a good day for Donna Adelson. They're going to have to regroup. And you see, time helped the state. They found this email now that they can use to cross Charlie and to cross Donna to show how this defense is not realistic.
Vegas vibes, great question. COE is the only one that can answer this. Where can we get an STS hat like yours? I want one. COE, what's up with the merch store? Let's make hats available. Please.
You bringing stuff up to Tallahassee?
I'll bring you. I got a couple of new hats for Tim Jansen. Make hats available again, Bugs, please, aka COE. STS did do this. We broke the news of Donna's arrest with live informed coverage. I'm not going to say whether Tim Jansen helped us or not with that, but we did break that news. And by the way, Tim is writing.
You can give me the credit.
Yeah, Tim is writing a daily column for the Tallahassee Democrat now on this. I think through the duration of the trial, right?
Yep.
Right, Tim?
Started my. We'll see. It might come out in Sunday's paper.
Here we go from Katie Cool Lady. Why would Charlie chip in on an ex-girlfriend and fake employee legal fees? Doesn't look too good for the defense, right, Tim Jansen?
No, never good when someone pays the legal fees of someone else that killed your ex-son-in-law, brother-in-law.
We are going through this hearing piece by piece. We're going to be done soon. So then they obviously argued about this 329-page PowerPoint presentation, and this is where got interesting because on page 20, there's a text from a person named Renee Griggs to Donna Adelson. I think she's a life coach. And she's explaining that this is prior to the murder, that her daughter can't relocate from Tallahassee to Miami, and basically expressing how stressed the family is. She says she's stressed about her son, but even more so about her daughter, Wendy, if she doesn't get the relocation. I don't know why she was so stressed about Charlie at that time. Judge Everett at that point basically said he wanted to know more about the context of this text message. What happens with that, Tim? It looks like that's going to be admissible too, right?
Another catch-all that the state will argue is context. It gives everything else, puts everything in context, not offered for the truth of the matter asserted, but it puts in context. I think she was arguing context of her motive at that time. That puts in context the stress she was under and motive she had to be involved in this murder.
Good question here, Tim. Who do you think the state starts with after openings? Who's the first witness that will be called?
I'm trying to look back who the first witness was before. Was it
I can't
Chris
remember.
Isom? Was it
I
Isom?
I think it was definitely one of the investigators. I just don't remember
I
who.
would think it would be an investigator.
There you go. Yeah, I think it'll be an investigator. So Tim, just basically, Dan Rashbaum went on to talk about page 318. There's a message between Charlie and Donna. That is, by the way, it was a message from August 2nd, 2016, after the arrest of Luis and Sigfredo. The state described these as co-conspirator statements. And then it's from Charlie. The actual message is from Charlie to Donna, his mother, saying about Sigfredo and Luis after seeing the arrest. Maybe those guys were in the wrong place. And he goes on to say maybe Danny stiffed them over a cocaine deal, saying it's just crazy. The guy admitted to selling cocaine. But Tim, they're saying this is all basically a message used to, if I understand it correctly, a message used as a decoy, right? As to say this is really what happened, not what we did. Is that right?
Yeah, alternate theory of the perpetrators who committed this offense.
And just by that notion that they're offering an alternate theory in these text messages makes it seem a whole lot more obvious that they are guilty of this conspiracy, doesn't it?
Well, it certainly goes to impeachment if they bring that theory up, and the court's going to allow this to come in for impeachment for an alternate theory in their state of mind at the time. And it's damaging. It's really damaging. And whoever found that at the state has to be really, really happy that they have that now, knowing what's coming.
Then there was another issue from page 324, and at that point, the judge was getting a little antsy, and I think it was Sarah Dukin just got up and said, "Look, we're not going to use that, so let's move it along." STS and Tim, I will be at the trial every day, starting with jury selection, starting next week. I will have to lie or lay in an Epsom salt bath this weekend to properly relax with cucumber slices over my eyeballs because I'm already fried from all this. Look at this, the COE already making a little gift bags for people in Tallahassee.
Right.
And a huge shout out. And I want to say it's Michelle. I hope I'm not getting that wrong. Literally sent me some FSU. I haven't even opened the box yet, but I know because that's what she told me she was doing. Sent me some FSU swag to wear to the game. The people in Tallahassee are some of the nicest people you will ever meet. So thank you for that. And then we end. Judge Everett asked Sergeant Chris Corbett to take the stand. He swears him in. He asked him if he's ever the state is questioning him to begin with. It was Sarah. Corbett says he's testified as an expert just a few times, 118 times as an expert witness. So he's going to be allowed to come in as an expert witness. The takeaway that I got is that there's this massive communication, massive PowerPoint, and Dan was trying to say this PowerPoint can't go back because it's all this information and only a little bit of it is relevant. And I think that's where he got a concession, if I'm not wrong, Tim, where what they'll be able to present the whole PowerPoint, but only a summary of the PowerPoint can go into the deliberation room. Do I have that right?
Right. A demonstrative, they can show to the jury. It can't go back to the jury. The summary can go back if it's pared down, opinions are taken out, and some of the smaller documents are taken out of it. I think that's the best ruling. Judge split the baby, and he's just such a great judge, right? He listens to everything. His reasoning on his rulings are right on, and he's not playing one against the other. So that's the kind of judge you want to appear before, because then the case is decided on the evidence. And he's great. Look at Jared.
Tallahassee is a great place to live. Don't believe Wendy. And Mr. Geiger, really the hero in all this, the next door neighbor. See here, he's the one.
Yeah, Mr. Geiger might be the first witness. I think he was the first witness.
I think he was. You're right. Yep. And everyone's
that's good work by Lindsay and them. Yeah,
KCL. Everyone's on it. How could we forget? He literally is the reason this is going to trial. I don't think he's ever spoken. Steve Cohen. We're gonna have to go. We have to go in with SWAT, break down that door, and make sure we get him as a guest on. We need a battering ram to get in there and make sure he's a guest on STS. Tim, how many days, people keep asking, of this trial do you think you will actually come to? You're going to be on the shows most nights, I hope. But what do you think?
Well, it depends on my schedule. I'll try to come. I'm going to try to do the opening. And then if I'm not if I'm in my office and not doing, I can do commentary during the live trial and do work while I'm doing it. But I will attend the trial certain days, and certainly at nighttime I'm available to meet you and do shows and, have
By
a
the
little
way,
hotty toddy.
Yeah, by the way, Ruth is watching this, she told me. So, Joel, COE, can you guys please remind Ruth, Phil, Shelly, how much we all love them next time you see her? Toronto's behind her every step of the way. Justice for Dan and the whole Markel family. There's a lot of work that goes into this, and the COE and I. COE, how are we going to do the show every night? Do we have a camera? COE, how am I going to do the lunch lives? Do we have that steady cam that I need? These are all things that we need.
You have a
location?
You have a location
No.
you're going to do?
Not really. We do things on the fly, Tim Jansen.
Well, you
I'm
know
not
where
gonna
my office is, right?
Yeah,
So
yeah. So
conference room,
you got to beef up that Wi-Fi. But maybe we'll go to Tim's after. Maybe we will go to Tim's after court. I'll have to talk to Tim. But COE, a lot of things need to get done between now and jury selection on Tuesday, including a nap for me. And as I said, cucumber slices for the eyes. Why would anybody, a couple more questions here, Tim from Tia Bawa, who's in the chat a lot. Why would anybody inquire about help for legal fees for Katie, who is part of the extortion team? Is there an answer to that makes any sense?
Yes. Many corporations hire lawyers for their employees. And there's an unsaid rule. Co-defendants, sometimes there's one defendant who's got tons of money, and that client would be willing to pay for the legal fees and the expenses. But you have to have an understanding, and I've done this where I've had to document that whoever pays, your loyalty is to that client, and the Florida bar rules have rules that you have to comply with. Your client's got to sign off on it, and you got to document it, that whoever's paying your fees, your loyalty is to that client, not to the people paying. He was correct, Dan says, when other people sometimes would cover the cost of expenses for experts and private investigators. That's true. It's allowable, but there's strict rules how that has to be done. And a lot of time a defendant will hire lawyers for other people just to have a contact or relationship, that the lawyers have a relationship.
So Tim, the momentum definitely feels like it is really in favor of the state. So the question from Michael Meehan, could they charge Wendy with a lesser charge or charges, followed by this one? Tim, do you expect Wendy now to be arrested? If so, would it be after Donna's trial? This is the question everyone always wants to know the answer to, Tim Jansen.
Well, they're not going to tell me if Wendy gets arrested. She hasn't been arrested yet. It seems like they're going down the line. And I think they're focusing on this trial like they did with Charlie. And what happens after that, who knows? I don't know. I haven't heard anything. No one's calling me and telling me. If they do call me and tell me, you guys will know, but I don't know.
Look at this. This is what I'm planning to do, by the way, Casey. I'll be doing the lunch lives right on the phone. There's the Metro Deli. That's the spot for lunch. I've even seen Judge Everett outside the Metro Deli waiting in line with the rest of the people. And I'll be doing lunch lives. I will respect Judge Everett. So if he's eating there, I will not bug him with my camera. Might give him a little
I remember Karen Reed. I did lives at the courthouse with my phone.
Yes, you
and
did.
A tripod.
And it was fantastic. COE is going to get me a little like a balancing selfie stick. How does that? KCL wants to know, Tim, when does the grand jury meet? Is there
I can tell you when the federal grand jury meets. They're usually called in a certain time, and I don't really keep track of the state grand jury because that's usually for police shootings and first degree murders. Really not something that is really of significance. I know exactly when all the federal grand juries because that's something more pressing for my clients, a lot of my clients.
Jared, if you happen to swing into the Metro Deli, please tell them that they better restock their shirt supply because I need a Metro Deli shirt, which I will do a lunch live in one day. Every time I go there, they're like, we sold out. COE, are my glasses smudged or is the camera focusing on the mic and not my face? I don't know. I love when Tim was a street reporter.
That was a lot of fun. That was fun.
Yeah, it was fun. Wesley John Holmes, we need a Metro Deli in Tokyo. You sure do. Tim Jansen, what is the biggest possible surprise bombshell development that you foresee that could happen or come from during this trial?
Wow, that's interesting. Bombshell. Maybe that they change their defense and do not argue the double conspiracy. That'd be interesting. But then I don't know why they would call Charlie as a witness.
And we're going to find that out if that happens in the opening statements, correct?
That we will know. We'll know in the opening statements. We should know. A good lawyer will present their defense in their jury selection, which I think that in my article I did for the Democrat, I talk about how the state has to hone in every day in jury selection and in opening circumstantial evidence, how it's admissible, how strong it can be, and now it's enough to get a conviction, because that's going to be their case, circumstantial evidence. And on defense, they're going to argue different points. They're going to argue that we'll see. I'm curious to see now if this changes.
Lisa here, this is a great point. Out of 87,000 emails reviewed from Wendy, and that's how much they said she had, and Donna had 57,000. Yeah, I'm sure she incriminated herself. Tim, you think she could have been flawless through 87,000 emails, or do you think that look at Doug Medler. He said this the other day. I don't know who Doug is. Could be Wendy. No way Wendy gets arrested. I think she's the only one saying that. But 87,000 emails, Tim, that's a lot of emails to keep quiet over a long period of time where your ex-husband was murdered. What do you think the chances are they find something in there?
Maybe. They've been pretty silent about it. I think they would like to charge her, but you still have the immunity issues. You have Castigar problems. You don't have any direct evidence against her. I just, I still see stumbling blocks for Wendy being charged, but there's certainly some circumstantial evidence also that's very incriminating that Wendy knew, and so we'll see. I'm curious to see as anybody.
Yeah, KCL saying 99% STS Nation is going to disagree with you. This has been a monster hearing, a monster week. Thank you all for joining us this show today with the hearing. 2 hours, 47 minutes, and now 2 hours and 48 minutes and 3 seconds.
Wow.
How do we thank Tim Jansen? I'll bring him a bottle of Bullet Bourbon once again. I did that last time, and I'll restock it now. Maybe I'll get him a different brand this time of something, and we'll
Bring
see.
me
Tim,
get a bottle of Camus.
Camus, okay, all right.
That's what I like. That's my favorite.
There you go, Steve Cohen. Did you hear that? So that's it. We're going to see Tim back here tonight at 7 p.m. Eastern time with 2 judges, and you're going to get interesting perspective from them. Tomorrow it is Scott and Phil at a little bit different time at 1:30 p.m. There is a nationwide manhunt going on that they're going to discuss tomorrow. And then we are off to Tally. On Monday, the COE is hosting the show, not related to this, but you should tune in for the COE, and we'll catch everyone this evening at 7 o'clock. These are the exotic places, the locales that were in the chat just today. As I say, love you, America. Uganda, the Netherlands, China, Edinburgh, Scotland, the UK. Scotland part of the UK? I have no idea. I think it is. Cape Town, South Africa, Japan, Windsor, Ontario, Canada. That is obviously near Toronto, which is the birthplace of, or not the birthplace, but the home of Dan Markel. He was born in Montreal. Denmark, Switzerland, Baja California, Mexico, Sweden, Norway, Australia, the Philippines, South Africa, and Mississippi. Someone said Mississippi. So Mississippi's included. And of course, Tallahassee. Justice for Dan Markel. Tim, you're the GOAT. COE, thank you. Space Coast, thank you. Mods, thank you. Steve Cohen, thank you. Mods, thank you again. And Greensboro, North Carolina. And look at this. Belize just slipped in. And look at this. India just slipped in here. That's a big one. It's a big country. If I could get everyone in India to watch STS, we would take over. We would take over Mr. Beast. See if you can help us with that. Love you all. Mark, this can't be true. Antarctica, no way. I don't think he's true. But Mark, if you really are in Antarctica, email me, survivingthesurvivor@gmail.com. I will send you a hat to Antarctica if that is really the case. Love you, everybody. See you tonight, 7 o'clock. Have a safe day. One more. Malaga, Spain. See you at 7 if I can get out of here. Tim, thank you. Tim, I'm going to call you later today.
Okay.
Oh, stick around, actually. Here we go. That was fun. I'm so friggin' tired because I did 2 shows. I did a show with Vinny yesterday, and then I had Yindra and Ryan on.
How was Vinny?
It's hilarious because he's on with my mom. My mom was like all stressed out, and she was just like yelling at. It was just crazy, but Vinny likes it, I think. So
Yeah.